For adjournments,
I'll explain it. It's a fresh filing, my lord. It's a fresh filing, my lord. CP, my lord.
the office objections are complied with, then
Yes,
listed case.
Yes.
Yes.
To list on
2014 matter, my lord, filed for the claimant. The insurance company has filed appeal, my lords. It is 2014, my lords.
Yes. No, that the page where the adjournments will call it.
Worship with respect to list number 2, item number 14. Withdrawing the petition, the matter has been settled by 30.
Is that? There are two petitions. What are the numbers? 14 and 15.
14 and 14.1.
14 and 14.1. In respect of these petitions, the memos are filed stating that the matter is settled between the parties and equally settled between the parties. Accordingly, the memos
So is the quote audible or visible to you, sir?
My lord,
My
he has
lordship,
taken
he is a
conservative
self-employed.
Let us look at that paragraph number.
para 22.
Hmm.
Yeah, arising out of MEC, my lord, 1591 of 12.
Hmm.
Fourth line, my lord. As per wound certificate, exhibit P15 and admittedly PW to hospitalize for 4 days and conservatively for the fracture of left leg. There is no operation, no surgery was done, only conservative treatment.
Now, where are you reading that?
Sixth line, my lord, of that para.
Para 22.
22. My lord, wound certificate, exhibit P15.
As per the wound mentioned, exhibit P15.
15, please. And
Hospitalized.
admittedly PW2
Conservatively.
conservative
Uh,
was inpatient for about 4 days. The medical expenses 37,137 has been incurred. The MSCT has granted compensation, total compensation of rupees 61,137. Lordship could have grant another 30,000 is global compensation that will be. Another 30,000 with interest may be granted. Global compensation.
How much is granted?
61,137.
61,137. You say another 30,000.
Another 30,000.
My lordship is an electric contractor whose jobs involves regularly climbing and all, my lordship.
No, it's
Such-
not that. When you say that, it's your duty to examine the doctor. If there is any disability, the doctor has to be examined. You are not examined the doctor. And how should the court pursue and presume things? Because there is no material. And and even the fracture also, they say that it is conservatively treated. No surgery, nothing. Yes, the agreed with the orders passed in MBC number 1591 of 2012. The claimant is before this court. The claim petition is filed seeking compensation of
3 lakh.
3 lakh for the injuries sustained by the claimant in the accident. It is a case with the claimant that he has sustained fracture and also he has sustained disability because of the injuries sustained in the accident. He has spent more than 50,000 for his medical expenses and he has produced the medical bills which are marked as Exhibit P16. The court had fixed a liability on the insurance company and held that the accident has happened because of the rash and negligent driving of the driver of the offending vehicle. When it comes to the compensation, the claimant has not examined anybody in support of his, not examined the doctor in support of his case, and the wound certificate and the medical records show that he has been treated conservatively. The court had considered the medical bills and has held that the an amount paid to the doctors as a professional charge in bill number 4, 5, and 7 cannot be taken into consideration. It has to be included in the final bill of the hospital for the treatment given by the doctors towards their professional charges. Hence, a sum of rupees 16,000 is deducted, and accordingly, a sum of rupees 21,137 is taken. And towards pain and suffering, an amount of rupees 25,000 is granted. Altogether, the court altogether the not 61,000
Incidental charges 5,000, loss of honor is 5,000.
and court had granted 5,000 towards incidental charges like payment to attendant and nourishment, and 5,000 for loss of enjoyment of life and amenities.
Another 5,000 later period.
and another 5,000 towards the loss of income during the laid up period. Which year is the accident?
The accident occurred in
Huh?
2012.
2012. What is the income as per the
7,000.
during the laid up period? And granted compensation of an amount of rupees 61,137. To open that door. Aggrieved thereby, the claimant is before this court. When counsel appearing for the claimant submits that the injuries sustained by the claimant have an impact on his future earning. This aspect was not considered by the court. It is submitted that when he had sustained the disability, or the court had not granted any amount, and even under the other heads also, the amount that was granted by the court is not just unreasonable. When counsel appearing for the insurance company submits that he was treated conservatively and he has not examined any doctor to show the disability. In view of the same, the tribunal had rightly granted the compensation and there are no grounds to interfere with the order passed by the tribunal. This court has perused, having heard the counsels on either side, perused the material on record. Coming to the aspect of disability, he has not examined any doctor in support of the same. That too, considering the fact that he has been treated conservatively, the court had rightly not considered the said contention of the claimant. The court has observed that he was hospitalized for how many days?
4 days.
4 days.
He was hospitalized for 4 days. And after that, for the injuries, under what head this 30,000 has to be enhanced?
Global amenities, parents suffering and all including additional 30,000.
And considering that, though there was no other evidence, considering the hospital bills and the hospitalization, this court is of the view that the claimant is entitled for another 30,000 towards global compensation. Accordingly, the appeal of the claimant is allowed by enhancing the compensation from 61,137 to 91,137. The enhanced amount shall carry 6% interest.
Interest 282 days.
Huh?
Interest of 282 days.
That's already order is passed. Look at it. Order sheet. Here it is.
22/6/2022.
22.
6/22. madam.
As per the order dated 22/6/2022, the petitioner is not entitled, the claimant is not entitled for the interest for a period of 252 days. Yes, next.
Number 2, Pradeep B.
Yes.
Preparing for the appellant.
Kindly pass over at 2:30, madam.
What is this?
Lordship, involvement of the vehicle is questioned. The IOI has been examined and who has filed a final report that vehicle is not involved in the alleged accident. Lordship has heard sometime, my lord.
Claim petition is dismissed.
No, my lord, I have challenging that. MSCT
Oh,
has
you are
filed-
the appellate.
Please.
Kindly pass.
Pass over.
Much obliged.
Yes, next.
See number 3.
Yes, you know, he was not there yesterday also.
Yes, ma'am.
Respondent.
Yes.
We'll hear it. No, not your case.
Serial number 3.
Yes, my lord.
Yes.
2 appeals prepared by the appellant. 2 appeals, my lord. Arising
3 and
out of
3.1.
MEC 64 of 12 and 65 of 12.
What is that?
My lord, MFA 6863 of 2015.
1 minute. 6862 of
Please, no, 6862 of 2015.
arises out of?
MEC 65 of 12, 2012. It's a case of death, my lord.
Next.
Another case, my lord, 68, 63 of 15, arising out of MEC 64 of 2012, my lord.
MBC,
64 of 2012.
this is 65. This is a case of injury.
Injury.
So first let's see the death, case of death.
Please. Exhibit P2, my lord.
1 minute.
Date of accident, my lord, 28/5. First page, my synopsis is there, my lord.
You are on what ground?
Negligence and quantum.
Negligence and quantum.
Quantum.
This is a case where you said pedestrian.
Please. As per
Yes.
Exhibit P2.
First, let's go to that that negligence aspect.
Please, my lord, Exhibit P2, my kindly.
Give exhibit P2. And the finding. In the meantime, let's look at the finding.
Please. Different judgment has been passed, madam, arising out of same accident.
Issue number 2.
Please.
Come to para 10.
The deceased Channamma was crossing the Tumakuru to Narsipura, Palkadu to Narsipura road near Shamudeva village gate at the time of driver of the lorry bearing number had come from Palkadu side and high speed in rash negligent manner and after engaging in human life rash taken as the deceased due to the impact he has sustained grievous injuries succumbed to the same after 2 days at St. John Hospital, Mysore. The claimant Lokesh, who is the son of the deceased, had
Is it a highway?
As for FIR, my lord, and complaint 59, the Palakadu police and others papers were proved that awareness of the petition, the contents of the police.
Yes, I am looking at the exhibit P2.
Please, it's the middle of the road. Middle of the road, the accident has taken place where there is no zebra crossing also.
I'll fix 20%.
Please. Regarding
What is the age?
Age 54 years, ma'am.
Occupation?
Agriculturist and milk vending.
Agriculturist
and milk vending.
How much income pleaded?
Pleaded 8,000, ma'am.
Court has taken?
6,000.
Which year is the accident?
28/5/2012.
It should be?
7,000. 6,000 as considered, and future process not added.
Multiplier is?
Multiplier 11. I'm challenging the 1/3 deduction.
Prospects how much? 25% or 10%?
10%. Regarding deduction, my lord, is a major son, 37 years.
What is his age?
34 years, my lord, before MSCT.
Who is the claimant?
Son only. Sole claimant.
What did the court do?
1/3 has deducted.
We'll do this.
50% sole claimant, my lord. Otherwise, my lord, should be there.
What is the evidence? Come to the evidence. With regard to his dependency, what is the evidence? What is the cross-examination? What you have elicited?
Please.
Give him that. If there is any evidence, we'll see.
Please, my lord. We have not cross-examined in that claim.
That's what generally done.
What was his avocation and what was earning? Not
Yes. So we will take 7,000. 10% is 700. That's 7,700. 1/3. $2,566. It comes to 5,133 into 12. What is the multiplier you
11.
said? 11. it comes to 6,77,556. Loss of dependency. Consortium 44,000. Funeral expenses 36,000. Comes to 7,57,556. Comes to 6,06,044.
5,70,000. My appeal may be dismissed.
Uh,
My appeal may be dismissed. No, there are
What is
claimants
the
are not
amount?
filed. 5,70,000 awarded. 20%, my lordship.
If it is
It's a
taken,
contributory negligence.
it would
And
come
also
to
my
six-
appeal will not survive.
the agreed with order passed in MDC number 65 of 2012, dated 2nd May 2015. The claimant is before the insurance company is before this court, questioning the negligence as well as the quantum of compensation that is granted to the claimants. It is a case of the claimant that on 28/5/2012, at about 5:30 p.m., when the deceased is crossing the Talkadu T. Narsipura Road, at the time, the driver of the lorry had come from Talkadu side at high speed in a rash and negligent manner and had dashed against the deceased. Due to the impact, she had sustained grievous injuries and immediately shifted to the hospital for first aid treatment and thereafter shifted to St. John's Hospital, where she was treated as an inpatient. It is a case of the insurance company that there is contributory negligence on the part of the claimant. This was negatived by the tribunal, and the tribunal held that there is no contributory negligence on the part of the claimant, and the accident had taken place because of the rash and negligent driving of the driver of the offending vehicle. And when it comes to the compensation, the court had granted the compensation of an amount of rupees
5,70,000.
5,70,006 as per the table given below. This is at page number 13, extracted. Then counsel for the insurance company submits that the accident had taken place on a highway where the claimant was crossing the road, where there was no zebra crossing. In that case, she has contributed to the accident. This aspect was not considered by the tribunal. This aspect was not considered by the tribunal. Then coming to the compensation, it is submitted that the claimant is the son is the claimant. His major son is 37 years old.
34 years.
34 years old, and he is not dependent upon the deceased. In that case, the court ought to have deducted 50% of the income. But in this case, the court had deducted 1/3, considering the son as a dependent. He submits that the compensation that is awarded by the tribunal is on the higher side, and not fixing the contributory negligence on the deceased was also bad, and the same needs to be interfered with by this court. The matter came up yesterday. There was no representation on behalf of the respondent. Even today also. But then this court has heard the counsel for the insurance company and posted the matter today as part heard. Today also there is no representation on behalf of the respondent. Hence the court is considering the matter on the merits of it. Next para. This court had heard the counsel for the appellant insurance company and also perused the material on record. The contention with regard to the rash and negligent driving, the insurance company has failed to examine anybody in this regard, and just like that, the court cannot. What is the time of the accident?
Time of
Night or day? Night or day?
5:30 p.m.
It has happened in the daylight, and they have not examined anybody. And just like that, on the ground that this is the that she was crossing the road where there was no zebra crossing, that itself it cannot be a ground to say that there is contributory negligence on the part of the claimant. Coming to the compensation, that the husband, the son, major son, is not a dependent. That contention also, this court is not able to appreciate in the light of the law laid down by the apex court in the recent judgment in Seema Rani's case. Seema Rani's case. Uh, Hence, in view of the above discussion, this court finds no reasons to interfere. Accordingly, the appeal of the insurance company is dismissed. The amount in deposit shall be forthwith transmitted to the trial court. Yes, next.
Number 4.
What about, no, 3.1.
Another one. Here, my lord,
Sir, I am sorry. Please.
Not necessary, it will be there in this. 3.1. It's a case for
sustained a fracture of my lord frontal bone.
how much?
7 days inpatient, my lord.
No. What is the amount granted?
Amount granted 95,000.
95,000. And same, she is also this claimant also crossing the road.
Along with
Who appears the same Harish Kumar.
please.
Now, having given a finding in that with regard to contributory negligence, it can be
Same.
given in that. So you have to be on
Quantum.
quantum. Let's see the quantum.
Para 13 and 14.
Para?
13 and 14. 13, my lord, 7 days inpatient, my lord. 14, fracture of frontal bone. 95,000. 95,000 it will be dismissed. Don't want to press that.
Agreed with the orders passed in MVC number. This is 64. MVC number 64 of 2012. The claimant is before this court. It is stated that same facts in the earlier matter, but she had sustained a
Injury.
fracture. Then on the ground, on the issue of contributory negligence, same finding. Then coming to the quantum, the court had granted the compensation as per the table given below at page number 13. An amount of rupees 95,000 is granted. This court, then counsel appearing for the same contentions, the counsel appearing for the appellant insurance company submits that the amount that is granted by the tribunal is on the higher side, and the court has failed to fix the contributory negligence. Same, even for not appearing also same. This court has heard the counsel for the appellant and perused the material on record. The claimant had sustained injuries and the court had granted an amount of 30,000 for pain and suffering, and even for the food and nourishment. And on the other heads also, the amount that is granted by the court is a reasonable amount, and this court is not inclined to interfere with the award passed by the tribunal. Accordingly, appeal is dismissed. Same amount in deposit. Yes, next.
Number 4. Shankar Reddy C. The appellant is connected.
Yes.
But the owner, my lord, has challenged the liability. The owner of the tractor has challenged the liability.
Hmm.
My lord, petition came to be filed, not stating that on
Now the liability is fixed on the owner.
on the
On
one
the ground that
on the ground that the tractor was not used as a water tanker. Therefore, when the water tanker is attached to the tractor, the policy conditions are violated. Therefore, the insurance company is not liable to pay the compensation. But insofar as the accident, my lord, is said to have taken place on 21/10/2013, complaint, my lord, is last 2 days later, and the vehicle, my lord, is not seized from the spot. 2 days later, my lord, it says that it has been recovered from the owner from his premises. The second aspect of the matter is, my lord, when the insurance company files their statement of objections before the court, they do not take up this contention. For the first time, my lord, it comes about in the course of evidence of the insurance company. One of the officials of the insurance company, when he examines as
What
RW1.
the police report say?
Police report, my lord, says that there is a tanker attached to the water. But it is 2 days later, my lord. 2310 is the date of the complaint. Accident, my lord, is said to have taken place on 2110.
What else you want?
Please.
What else you want? What is the evidence adduced by you that it was not a water tanker, but it was
They do
only
not
used?
raise such a defense in the course of their statement of objections.
No, exhibit P1 or that FIR clearly reveals it. Then some document is on
My lord,
before the
the
court.
insurance company also says that no such incident has taken place. And it is a collusion between the owner of the vehicle and the person who has suffered the injury. We have colluded with each other and created an accident. They do not even admit the accident.
In all the cases, that's how they file the objections.
My lord,
Accident
if-
denied, the
my lord,
driver
if-
of the vehicle is not having a valid driving license. That's a general format. Then they will come up with, that's how it happens in every case.
Not normally, not when the statement of objections are filed, not everything will be denied. At least when they put forward their case, not they should have not brought to the notice of the court. This is what their defense is. Not I have denied it. I have denied it, not stating, not
What had happened to the case?
please, my lord.
Criminal case, what has happened? They filed a charge sheet.
They have filed a charge sheet, not
The charge sheet also, it reveals, as per that also, you are running it as a water tanker instead of using it as a tractor.
not charge
And
sheet.
any,
Not
you are not
charge sheet.
supposed to attach anything to that tractor.
Not charge sheet is filed against the driver,
Driver of the,
tractor. Driver of the
you are the
tractor.
owner.
No, I am the owner.
You are liable vicariously.
Not I do
And you are
not.
you are the policy holder, the
Not I am
insurance.
the policy holder, my lord. I deny that I have, my lord, running it for, my lord, transporting water.
Well, what
I've
evidence
said,
you
my
have
lord,
placed?
my case is, my lord, that it has been used for agricultural purposes only. And when they do not take up a specific contention in the course of the statement of objection,
Whom you have examined?
Lord, I have not examined anyone. Lord, I have not examined anyone because
There is no, in all these cases, either we go with the police records, medical records. Police records are against you. In that case, when you're denying it, you have to examine somebody.
not in the first instance, my lord, the burden is on the insurance company. Lord, when they say that no such incident has taken place and it is a police,
First instance, the burden is on the claimant to prove that the accident has happened
that is
because
for
of the
them, that is for
negligence,
them to prove.
because of the negligence on the part of the so-and-so, that they have discharged. That they have discharged.
Please, ma'am.
And there is a finding that the vehicle is involved in the accident.
Please, ma'am.
Now it is for you to say that the vehicle, that both, it is both on you and him. It is not that exclusive burden of the insurance company.
Please, ma'am.
That you are not discharged. And the police record speaks otherwise.
Not that filing of a charge sheet, my lord, is not conclusive proof. Not,
Provided there is some other evidence
not when I
on
deny,
record.
when I deny, my
Mere
lord,
denial is not sufficient.
not, if that were to be the case, my lord,
Then you have to examine somebody saying that, you have to examine your driver, saying that on that day, it was used as an agriculture, for the agriculture purpose, used as a tractor, but not as a tanker.
Please.
That you have not done.
not all this would have been, my lord, right, if the, on the date of the accident, if a complaint is lodged and the vehicle is seized on that particular place.
Yes, I understood your line of argument. Yes, what about
My
the,
appeal is for enhancement.
yours is for?
Enhancement.
Hmm.
And also the liability being fastened on the owner. It has to be on the
Yes.
insurance company.
Pradeep, what do you say on the liability?
Regarding liability, my lord,
No, there are pay and recover.
owner's appeal is also
Not,
there.
Owner's
is
appeal.
Owner's appeal, like, we will discuss his appeal. As far as the claimant appeal is concerned, we'll say pay and recover, and we'll consider whether there is any scope for enhancement. We'll come to that aspect.
Lords may kindly take paragraph, issue number 2, page number 29, my lords. Ink page 29, internal page 16 of the judgment. The claimant, my lords, has sustained compound fracture of left leg.
No page number, internal page?
Internal page 16 of the judgment, ink page 29, my lords. Issue number 2. Num appeal 7055 of 16, my lords.
No, refer to the judgment.
Judgment, my lords, judgment page number 16, my lords.
Not necessary.
Paragraph number 18. The petitioner has sustained the injuries in the accident. He has relied upon exhibit P6, that is own certificate, issued by Sparsh Hospital, Bangalore. Exhibit P6 reveals that the petitioner had sustained the following injuries: compound fracture of left leg, compound fracture of left foot, uh, cut lacerated wound of left forearm. As per Exhibit P6, injuries are grievous in nature. There is no much dispute with regard to the injuries sustained by the petitioner. In view of the findings recorded on issue number 1, the petitioner has sustained injuries because of the actionable negligence on the part of the driver of the tractor bearing number so and so. Hence, the petitioner is entitled for compensation.
How many fractures? Two fractures.
Two fractures, my lords, but both are compound fractures.
Pain and suffering 60,000.
And my lords, he has produced the bills for 3,03,527.
No,
that
let's
has been
go
sat-
next.
Please, please.
The evidence of PW1.
It is the evidence of PW1 that he has spent a sum of rupees 5 lakhs towards medical expenses, conveyance, nourishment. The petitioner has produced 77 medical bills at Exhibit P17 to the tune of 3,03,527. The petitioner has produced 30 prescriptions in connection with the said bills before this tribunal, and they are marked as Exhibit
So
P.
whatever is the place is granted.
Please, Millards, whatever has been, Millards, and the next aspect is that Millards, income. Millards, conveyance and nourishment, Millards. He was inpatient for about 17 days,
How
and
much is granted?
10,000 is granted under food and nourishment.
3 8s
Millards.
are bifurcated.
Uh,
3 8s are bifurcated. Total 35,000 has been granted.
but then it's a good amount because food, nourishment, transport, attendant all together we are considering
35.
1,000 like. So in that case, how much is the amount?
35.
In all the heads,
All the heads 35,000.
attendant, food and nourishment. Attendant, transport and nourishment. 30?
5,000.
35,000.
No, it's a good amount.
And on the head of loss of income during laid off period, Millards. Income taken is at 7,000. Accident, Millards, is of the year 2000.
Quota taken,
7,000 is taken, Millards. And for 3 months,
according to you, is your income?
Millards, as per his self-testimony, Millards, he was earning 500 rupees as a tailor. As a tailor, Millards, he was earning rupees 500 per day. That's what is his
15,000 per month.
15,000 per month. Millards,
So
even if
taken-
the
which
local adult is taken, Millards, please,
How many months quota is granted?
3 months.
3 months.
24,000.
Millards, he was inpatient for 7 days and multiple surgeries have been undergone, Millards.
34th month will grant 32,000. Yes, next.
And future loss of earning also, Millards, has to be enhanced as the income has been enhanced.
No dispute on other things. On disability and all.
Future medical expenses is not at all awarded,
No,
Millards.
no, no. Future earnings.
Future
No
earnings,
disability
Millards.
on.
Please.
No, on this.
No, Millards.
Loss of future earning. We are taking the income at
8,000.
8,000 into 12 into
16% the tribunal has.
what is the multiplier?
18
years,
Millards.
18 months.
18 will be the multiplier.
Disability is
16% to the whole body.
18 is a 18 into 16 by
2,76,480.
And future medical expenses ought
One
to
minute,
have given.
1 minute.
Yes, please.
2,76,480.
Correct.
Loss of amenities.
20,000 is awarded, Millards.
Is there 10,000 will grant?
Millards, marriage prospects also has to be taken into consideration, Millards, because 16% disability is there, and there is stiffening of muscles and all. 19 years old boy, Millards, and tailor by profession. That may kindly be considered, Millards.
Loss of marriage prospects, another 20,000.
Future medical expenses is not at all awarded.
What is
Millards.
required for
Millards,
future?
he has undergone surgeries, Millards, and
No, what is the
because
evidence for that? What is the future requirement?
PW2 doesn't say that.
There is future requirement. It should be there on the evidence.
Internal page 24 Millards. internal page 20. PW2, that's the doctor, has not spoken anything with regard to the future treatment.
Yes, legal expenses 10,000.
After I downloaded the app, it says
Mute that.
64 bit. It comes to 7,67,000. Please come.
The owner has deposited the statutory amount or any amount. Remaining amount I had to pay and recover them. Whatever they deposited may be transferred to MSCT for discussion.
Agreed with the award passed in MVC number 217/2014 dated 29 February 2016. Both the owner of the vehicle as well as the claimant are before this court. The owner's appeal is 4457 of MFA 4457 of 2016 and the claimant's appeal is MFA number 7055 of 2016. The claim petition is filed seeking compensation of an amount of rupees. How much is sought?
15 lakhs. 15 lakhs.
Seeking an amount of rupees 15 lakhs to which the compensation. It's a case of the claimant that on 21/10/2013 at about 4:30 p.m., the claimant was proceeding as a pillion rider in a motorcycle. And it was ridden by his friend, one Bharat, on the left side of the road. When the motorcycle reached near Kadmut Sandra Gate, Raka Hubli, Malu Taluk, Kola district, the tractor came from the Kadmut Sandra Gate in a rash and negligent manner without observing traffic rules and dashed against the motorcycle. Due to the impact, the claimant and the rider of the motorcycle fell down and sustained multiple grievous injuries over the body. He was taken to the hospital and he has spent huge amount towards the treatment. When it comes to the liability, the tribunal has held that the contents of Exhibit P1 to P6 prima facie establishes the rash and negligent driving of the driver of the tractor. Where do you get that there that with regard to the water tanker?
Para 29.
29.
Para 29. Page not, it is forthcoming. RW1 has deposited that the company has issued a
It's the court has observed that the company has issued a commercial vehicle policy to the tractor. The said tractor, what is this? The company has issued a commercial vehicle policy to the tractor.
agriculture tractor.
The said tractor is an agriculture tractor and is being used as a water tanker as on the date of the accident, as with the second respondent, has violated the terms and conditions of the insurance policy. And the respondent has produced a copy of the insurance policy, Exhibit R1. It is clearly mentioned that the insurance company has issued policy for agriculture tractor GT. As per the records placed before the tribunal, the policy was issued for agriculture tractor and not for the trailer and tanker. Therefore, The owner of the tractor has violated the terms and conditions of the policy, hence respondent number 1 is not liable to indemnify the insured of the offending doctor, and the owner, that is respondent number 2, is liable to pay the compensation, and accordingly liable to pay the compensation. When it comes to the compensation, court had granted an amount of rupees 6,61,447 as per the table given below. It is at page number 25, extracted. Learned counsel appearing for the owner of the vehicle submits that the complaint is given after 2 days from the date of accident. They have never used the vehicle for the purposes as stated, that they have been using it as a water tanker. According to the learned counsel, the same is used for the agriculture purpose, and this the tribunal basing on the police records had uh, had given a finding that there are the owner has violated the terms and conditions of the policy. It is submitted that the burden lies on the insurance company to prove that the same is used for the for the purposes for other than the purposes for which the insurance policy is issued. And the court, without considering all these aspects, had fastened the liability on the owner of the vehicle, which is not, which is contrary to the material on record. It is submitted that the charge sheet, basing on the charge sheet, the court cannot give such a finding. Next paragraph. Learned counsel appearing for the for the claimant submits that whatever or the violation of terms and conditions of the policy, the claimant being a third party to the insurance policy, he is not concerned with the same, and the court ought to have applied the theory of the principle of pay and recover. Pay and recover. It is submitted that when it comes to the compensation that is awarded under the head of pain and suffering, and the income that is considered, further the loss of future earnings, loss of amenities in life, the amount that is granted by the tribunal is on the lower side, and it needs to be enhanced. Next para. Learned counsel appearing for the insurance company submits that the tribunal had rightly considered the evidence on record and rightly held that the insurance company is not liable to pay the compensation, as there is a clear violation of the terms and conditions of the policy. And even on the compensation also, court had granted a just and reasonable compensation, and no interference is called for. Next para. Having heard the counsels on either side, there is the material on record. First, coming to the aspect of liability, a crime was registered against the driver of the vehicle for his rash and negligent driving, and in that there is a description about how the vehicle is used. As per the FIR and the other reports, the vehicle is used as a tanker, whereas the policy is issued for the agriculture purposes. The the contention of the land council appearing for the owner of the vehicle is that the burden lies on the insurance company, which this court is not able to appreciate. When an application is filed under 166, the initial burden lies on the claimant, which the claimant had uh, had uh, uh, had discharged, and now the now if the the other records that are available on the that are placed on record, if the insurance company, if the owner of the vehicle is disputing the same, he should have adduced evidence. Admittedly, in this case, no such evidence is adduced. In that view of the matter, this court do not find any reasons to interfere as far as the said finding with regard to the liability, that the owner is liable, and the appeal of the owner of the vehicle has to be dismissed. Coming to coming to the case of the claimant, as rightly argued by the learned counsel, the claimant is a third party to the insurance policy. Even if there are violation of the terms and conditions of the policy, it is between the owner and the insured, the insurer and the insured. Hence, in the light of the settled law, the insurance company shall pay the amount and recover the same from the owner of the vehicle. Next paragraph. Coming to the compensation, the claimant had sustained two fractures. Under the head of pain and suffering, this court is inclined to grant an amount of rupees 60,000 towards medical bills, attendant, transport, nourishment. The court had granted a reasonable amount, and this court is not interfering with the same. Then coming to the loss of income during the later period, this accident had happened in the year
2014 Millards.
2014.
13.
2013. The 2013.
13, 21/10/2013.
2013. The court had taken the income at 5,000,
7,000.
7,000, considering considering the chart prepared with the Legal Services Authority. This court is taking the income at 8,000, and for the injury and considering the injury sustained by him in the hospitalization for 4 months, an amount of rupees 32,000 is granted. Coming to the loss of future earnings, as and taking 8,000 into 12 into 18 into 16 by 100, the amount is 2,76,480. Loss of amenities, considering the disability of 16%, this court is granting 30,000. The loss of for the loss of marriage prospects 20,000. In the light of the law laid down by the apex court in Mekhala versus so and so, the an amount of rupees 10,000. Altogether, the claimant is entitled for an amount of rupees 7,67,007. The enhanced amount. Any delay in this?
88 days, but there is no condition.
Enhanced amount shall carry 6% interest. The next part, the appeal of the claimant is partly allowed. The enhancing the compensation from 6,61,447 to 7,67,007. Number 2, the enhanced amount shall carry 6% interest. The same shall be paid by the insurance company and shall be recovered from the owner of the vehicle. Number 3, the amount in deposit shall be forthwith transferred to the trial court, and the said amount, the claimant is in addition to the remaining amount, the insurance company shall deposit, and the claimant shall deposit, and the claimant shall withdraw the same.
Recover the same from the and recover the same from the owner of the vehicle.
That is already said.
Serial number 5, Pradeep B.
Yes, 1 to 3 minutes. Challenging the quantum of compensation. Quantum only. Give the synopsis.
Case of death or injuries. Take that.
The date of accident at 7/10/2013. Staged over 31 years. The income taken by the tribunal at 8,000. It is as per the chart, my lord. There is no dispute on that. The future prospect added 50%, my lord, instead of 40%. He was 31 years old. And my lord, interest awarded 9%, my lord, instead of 6%. That's all, my lord.
But so far as with respect to the compensation which has been given, my lord, sir, for 3 persons, what they have given is 1 lakh rupees. If that is taken into consideration, my lord, sir, so far as with respect
Your
to-
appeal is not there.
No, I'm,
Will not consider all that. Now, as far as their appeal is concerned, for future prospects needs to be at 40%.
my lord, sir, so far as with respect to interest is concerned, my lord, sir, that may be reduced to
It has to
6%.
be 6% in
It
order
has to be, but is the only son as on that date he was earning, my lord, sir, that may be considered. And he was the only son as on that day was working, and
Who are the claimants?
claimants
Mother and
are
sisters.
mother and sisters, sir.
Oh. How much is deducted?
Deduction 50%, correct. Bachelor day.
Bachelor.
Oh, is bachelor.
Bachelor.
And consortium?
1,25,000 conventional has been granted. Total 1,25,000.
Otherwise, how it count? 88,000 plus 36 is?
38,000 plus 56.
It comes to 1,24,000.
124.
How much is granted?
125.
125.
That is also, then what else you will get?
So,
That is also correct.
Their contention is there is two
No,
sisters.
even without your appeal, even under the conventional heads, if this court has to enhance, that also you got it.
I do agree, my lords. My only submission is that with respect to interest is concerned, matters let to be modified. The other aspect let to be remain the same. That's my only submission.
But in all the cases, court is consistently doing it. So there can't be any exception. Because in all the cases, appeals filed with insurance company, if it is more than 6%, it's been reduced. Where is the table?
Table internal
Page
page
number-
21. In the synopsis only I have written all this.
So loss of dependency is income is
8,000.
8,000.
future prospects at
40%.
it's
3,200.
3,200.
3,000.
200, that is 11,200.
Please.
Half is
6,500.
hmm?
6,500. 5,600. Sorry, 5,600.
5,600. So 5,600 into 12 into
16. 10 lakh 75.
10 lakhs and
10 lakh
75,200.
75,000.
200.
Right.
Then under the conventional heads,
1 lakh 25.
1,25,000.
consortium plus spindle
12 lakh 200.
plus funeral expenses 1,25,000. It comes to
12 lakh 200.
12 lakh.
200.
100.
So how much is reduced?
77,000.
77,000.
77,
67,800.
76,000, 75,000. Now it becomes 75.
76,800.
75,000 is reduced. Agreed with orders passed in MBC number 2271 of 2014 dated 28th April 2016. The insurance company is before this court. The court had granted compensation for the death of deceased as per the table given below. Land counsel for the insurance company submits that the age of the claimant as on that day was
31 years.
31 years.
31 years and he was earning an amount of rupees, how much?
8,000 per month.
No, 30,000. Your earnings as per the your
According to him, he was earning 30,000 per month.
15,000.
15,000 per month.
15,000 per month, and court had taken
8,000.
8,000.
court had taken 8,000 per month as income. He submits that considering his age, the and the occupation, the future prospects have to be taken at 40%. In this case, the court had taken 50% as a future prospects. It is submitted that the interest that is awarded is
9%.
9%, which is on the higher side. Then counsel appearing to the respondent claimants that the court, considering the evidence and the death of the deceased, has rightly granted the compensation, and there are no grounds to interfere with the same. Next part, having heard the counsels on either side, there is a material on record. Considering the age of the claimant and the occupation, the future prospects have to be at 40%. So considering 8,000, the future prospect at 40,000 will come to 3,200, that's 11,200. And as is a bachelor, 50% has to be deducted towards his personal expenses. And his contribution to the family would be 6,000, 5,600. 5,600 into 12 into 16 is 10,75,200. The court had granted towards consortium and funeral expenses 1,25,000, which is correctly given. So all put together, the claimant is entitled for an amount of rupees 12,200. Coming to the interest is reduced from 9% to 6%. Accordingly, the appeal of the insurance company is allowed by reducing the compensation from 12,77,000 to 12,200,000, and the enhanced the amount is the rate of interest, it is reduced from 9% to 6%. The amount in deposit shall be forthwith transferred to the trial court, to the tribunal.
Serial number 6. Tejas Rai.
In this case, a waxy function, my lord. Who is on record advocate is in the end of under court.
Pass over.
Please.
Next.
Serial number 7.
Filing. IA for modification last time. Last directed me to file. There was an order. Restrict the interest. Take that, Bindu. Heard the argument for enhancement. No, how can this be before me? If this lordship goes to the. No. Like it will go before you are seeking a review of the order, isn't it? If I remember, with regard to the order passed by the other learned judge, you wanted to file a review and come before this court. How can you give this affidavit to me? You have to file it. It will go before him, as far as that application is concerned. At the request, let this matter after 2 weeks. Yes, next.
For dismissal, serial number 8.
The matter is settled. We were agreed for a
Giant memos.
2,25,000 as against 15,000 awarded by.
Yes.
We are filing the joint memo, my lords.
A joint memo is filed before this court stating that the matter is settled between the parties. The third respondent, insurance company, has agreed to pay some more rupees 2,25,000
Inclusive of interest, my lords.
as global compensation,
Yes.
inclusive of interest. What is that?
As against 15,000 awarded by the tribunal.
Amount of rupees 15,000 awarded by the tribunal. Accordingly, the joint memo is taken on record, and placing on the said joint memo, the appeal of the claimant is allowed by enhancing the compensation from an amount of rupees 15,000 to 2,25,000 and 25,000 without interest.
Yes, my lords.
Amount to be deposited before
Yes,
the tribunal.
we would deposit before the tribunal.
All that will
Yes.
follow, order will follow.
Much
Yes.
obliged.
Serial number 9. Sri Sitaram Rao.
Appeal for respondents, my lord.
Where is Mr. Sitaram Rao? Who is my head?
Serial number 9. Anu.
Malaj, serial number 9, Malaj, kindly pass over, Malaj. Senior will argue the matter in the afternoon.
Yes, next.
Serial number 10. Vasantappa.
My lord, owner's appeal, my lord, challenging
Who
liability.
appears to the respondent?
Respondent, my lord.
They have also filed one more appeal.
My lord, I
Connected.
keep for tomorrow, my lord, today is inconvenience.
Why every matter, morning one matter passed over?
Otherwise, my
But-
lord, matter may be referred to Lok Adalat. Since owner liability.
Submitted that the matter may be referred to the Lok Adalat. She is directed to place this matter to the Lok Adalat. Yes, next.
Serial number 11.
Yes.
T. Sheshagiri Rao.
I have filed no objection, Wakalat. My name is Vishwanatha and TV Nanjay. Caste title.
Where is Mr. Ravi S. Samprati? He was here just now. If he is here, we'll just, if possible, we can dispose it of. Yes, Mr. Is it a case of death or injury?
Injury case, my lord. The injured was a police head constable.
Police head constable.
He was aged around 51 years.
Hmm.
The accident has occurred on 27/7/2013.
27?
7/2013.
Hmm.
an amount of rupees 6 lakhs was claimed.
6 lakhs claimed.
Claimed.
Hmm.
The award was around 1 lakh
1 lakh
7,000.
Hmm.
But he has suffered fracture of right medial malleolus.
Hmm.
The doctor is examined and he has assessed disability to an extent of 11.66%.
Hmm.
Because he continues to work as a police constable, court has not granted any compensation on the head of loss of future earnings. He's an admitted practice. He has
Then loss of immunities, how much amount is granted?
30,000.
30,000.
Pain and suffering 60,000 is granted.
And conveyance nourishment
No,
put
but
under.
loss of, because whether though he is continuing in the job, the court might have not granted future earnings, but amenities we have to, because considering the nature
So
of the
that,
job.
my lord, that's the reason why 60,000 rupees is granted.
Let's see the table. Pain and suffering.
60,000.
30,000.
Talk about 30,000. Incidental expenses 17,000.
2 fractures.
Only one fracture.
One
Fracture of medial malleus.
How many days he was in hospital?
17 days.
He was
17.
28/7/2013 to 14/8/2013.
How many days?
It's around 17 days.
That is also reasonable.
Only with regard to liability, madam.
But the claim petition is dismissed against the insurance company.
Oh, you are on the liability. No, first we are on enhancement.
Enhancement
on
and also
what
liability.
grounds enhancement is required, I'm asking you. Now, conveyance for 17 days, 17,000. Loss of amenities, if at all, I think here we can, increase another 20,000 because future earnings is not granted.
And future medical expenses not granted.
Huh?
Future medical.
What is the evidence for that?
Evidence is 30 to 40,000 is required for removal of implant.
Oh, removal of implant is there. Which year is the accident?
13 million.
30,000 under this. Then, now come to the liability. Now, this is what it is. Legal expenses, 10,000. On what ground the owner is held liable?
Well, the driver did not have driving license. And the
PL.
driver is charged.
Huh?
The driver is charged under section 3 subclass 1 and 181, and the owner is also charged under section 5 180 of the MV Act.
Pain record.
Paint.
Agreed with orders passed in MAC number 5403 of 2013, dated 13 February 2015. The claimant is before this court, seeking enhancement of the compensation and also questioning the liability on the fixed on the owner of the vehicle. The court had fixed the liability on the owner of the vehicle as liability considering the charge sheet filed for the offences under section 279, 338 of IPC, section 3(1), read with section 181, filed read with 180 of the MB Act, alleging that the driver do not possess a valid and effective driving license at the time of the accident. And the court has held that as it amounts to violation of the terms and conditions of the policy, and the insurance company is not liable to pay the compensation and fasten the liability on the owner of the vehicle. In the sight of the settled law, the principle of pay and recover will apply, and the insurance company is liable to pay the compensation. Then coming to the compensation, Land Counsel for the appellant submits that the court had not granted loss of future earning and future medical expenses are not granted. Land Counsel appearing to the respondent insurance company submits that the court had rightly not granted future expenses because he continued in the job, and the evidence clearly shows that there is no loss of future income. Next, having heard the counsel's on either side, there is a material on record. Under the head of pain and suffering and conveyance, court had rightly granted the compensation. Then coming to the loss of amenities, an amount of rupees, for an amount of rupees 20,000. This court is inclined to grant an amount of rupees 30,000 as loss of amenities towards the future medical expenses in the light of the evidence of the doctor, as the implants have to be removed. Another 30,000 is granted by this court. Then, in the light of the law laid down in vehicle also so and so, towards legal expenses 10,000. Altogether, The claimant is entitled for an amount of rupees 1,47,000. Accordingly, the appeal of the claimant is allowed by enhancing the compensation from 1,07,000 to 1,47,000. The enhanced amount shall carry 6% interest. The amount shall be paid by the insurance company and shall record the same from the owner of the vehicle.
Serial number 12, Sirimalaya.
No, in serial number 12, my lord, Mr. Vijay Kumar requested 230, my lord.
230. Next 30.
Serial
13,
number 13.
serial number 13.
Yes.
But only ground, my lord, whether trial court has exonerated the liability of the insurance company and fixed the liability of the owner, saying that that license was for the LMV, but not for a non-transport vehicle. So
Transport non.
that is only.
No, but it's light motor vehicle.
Please.
Not about transport, non-transport.
That is the only ground. That is the.
No. What is the vehicle involved in the accident?
Maxi cab, a tempo traveler, maxi cab. So that is a vehicle that is involved in the accident, which is caused the accident. So now the responsibility has been fixed based on that particular that there is no endorsement on the license saying that like LMV and not NT, non-transport vehicle. That is on.
Yes.
That is being covered by the judgment of.
Mukundevan. Yes, Mr. Mahesh Mukundevan.
Yes, here you also kindly see, my lord, that the owner has not let in any evidence before the tribunal, and the tempo traveler, my lord, RC book is not produced to show what is the laden weight and unladen weight. To apply, my lord, Mukund Devan case, on the contrary, RW1 RTO, my lord, was examined, and in the light of, my lord, his evidence in corresponding to exhibit R1, court held that he was not having a valid license. Therefore, my lord, the insurance company was exonerated. If he produces the registration certificate, my lord, that will clean the issue.
Yes. Please come.
But that para 4 of the judgment clearly covers that this is what the license that is being produced.
Agreed by the order passed on MSC number 15550/2015, dated 10th August 2016. The claimant is before this court questioning the liability that is fixed on the owner of the vehicle. The court had exonerated the insurance company and fixed the liability on the owner of the vehicle.
Exhibit P10 is a copy of the DL that is being produced. Exhibit P10 is produced as a DL that is there on the record.
What I require registration certificate to know the weight of the vehicle.
No, that I understood. Where is which para is finding?
Para 17, my lord.
17. Internal page 15.
The tribunal has held that there is no dispute over the respondent number 2 is the owner and the respondent number 1 is the insurer. It is the court had considered the contention of the insurance company that the driver who was driving the tempo traveler was holding the license to drive LMV non-transport only. Firstly, there is clear recital in the charge sheet as the driver of the tempo traveler was not having the holding effective driving license. Secondly,
RTO was examined as RW1.
RTO has been examined as RW1 and he has produced the driving license extract. By perusing this expert R1, it is pertaining to the Shivaraja, who is the driver of the tempo traveler at the time of the accident. And further, RW1 deposed that as per exhibit R1, the holder has authorized to drive only LMV non-transport to drive tempo traveler passenger vehicle. Driving license is must. Further, the holder of exhibit R1 is not authorized to drive tempo traveler passenger vehicle, and accordingly, court has held that the insurance company is not liable to pay the compensation. Next para, when counsel appearing to the claimant submits that in the light of the law laid down by the Honorable Apex Court in Mukund Devigan's case, the insurance company is liable to pay the compensation. When counsel appearing to the insurance company submits that no evidence is placed before the court that what is the laden and non-laden weight of the said vehicle. In that regard, RC book is not placed before the court. Next, having other counsels on either side, there is the material on the court. The whole finding of the court with regard to the LMB transport and non-transport is the ground for fixing the liability on the owner of the vehicle. This matter clearly covers as per the judgment of the Honorable Apex Court in Mukund Devgan's case, and the insurance company is liable to pay the compensation. Accordingly, the appeal of the claimant is allowed.
Let him pay the interest, my lord. Owner not having, well, let in any evidence, let him pay the interest.
Lord, there was a deposit of 25,000 that has been made at the time of filing this appeal.
And there is a delay in pushing the appeal.
Please, no, owner of
He is the owner.
Amount in deposit shall be forthwith transferred to the court. Yes.
For order serial number 14, M. Venkatesh.
For the respondent, my lords, and my appeal is also there for enhancement.
My lord. In 14, my lord, I am yet to submit the submitted to the court, my lord. A week's time,
No.
I am yet to receive, my lord. I have given, I am yet to receive.
No, you please
week,
argue.
any date, my lord.
No, will not grant. You please argue basing on the documents you have, and
my
we'll
lord,
understand.
Pass over the matter.
Yes, pass over.
Serial number 15.
This
What about
is
15?
appeal by the insurer, my lord.
Yes.
On liability.
Yes, give the file.
Initially, the case was filed by the claimant to Mysore MACT. That MVC
You are questioning the
540
liability on what ground?
My lord.
Appeal on what ground?
Appeal and liability, my lord.
What is that?
Initially, claimant filed the MVC 540 of 10 before MACT Mysore. The charge sheet I have placed before this court. That was dismissed for non-prosecution, my lord. Without disclosing that, he files later at MVC 28 of 09 before the Lord.
Then what is the finding of the court in this?
More than that, in WC matter, there is no employee-employer relationship between the claimant as well as the owner, my lord. Both R1 and R2 placed expert before the MACT. I have only appeared, I have taken the contention.
Mr. Venkatesh,
MVC filed on page 5, my lord.
No, this matter is continuously being listed from Five 2024. From the last 1 year, this matter has come up 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. From the last 12 locations, every time you are seeking adjournment in this matter. What is the reason for that? 2013 appeal. It's unfair.
Come to page 5, my lord, because majority of the documents are in Kannada. Kindly
no,
come
Kannada
to...
problem is for this court, not to the other courts. Yes. But you have been taking time from the last 1 year.
Kindly come to the order sheet which I have filed before this court, madam. That dismissal of MVC for DNP for non-prosecution. MVC 540 of 2010. MACT.
Where did you file? When did you file?
My lord, kindly.
This is a petition.
That's the petition, my lord. Our sheet has the page number 1 behind, second page. That's what dismissed for non-prosecution. No, page 1, my lord. Order sheet of a learned MACT. After dismissal, DNP, it has to be challenged before this court. Now, review petition might have been filed before MACT.
When was it dismissed for default?
Dismissed for default. 38/2011, my lord.
Yes.
And without bringing it to notice of the court, they have filed a WC. R1 and R2, who is said to be the owner of the vehicle, placed ex parte. There is no employee, even for that also. That is challenged before this court, my lord. Without challenging the order passed by the learned MACT Mysore, nor disclosing that before the court commissioner, they have filed its WC, my lord. It has to be dismissed, my lord.
If you have such a good grounds, why were you not contesting it? Why were you not arguing it from the last so many occasions?
No, unless they challenge the.
No, that I understand.
Yes, one.
When you are putting forth all these grounds,
Please.
and we have a good case, why were you not arguing from from the last 1 year?
I have no reason, my lord.
Reason for that?
I am sorry, I have no reason to submit to the court, my lord. I am only assisting the advocate on record, my lord. I have nothing to say.
Are you sure that later no application is filed and they have not sought for any liberty?
No, my lord.
I will record that.
Please.
Come. Please tell to whom you are assisting.
I am assisting
matters will
Mr.
not
Venkatesh,
be-
AM Venkatesh.
I know that.
Please.
Tell him that matters will not be adjourned like this. And what I'll do is from hereafter, if these old matters are sought for any adjournment, I will impose exemplary costs for this. Who will pay, will pay.
Please.
Agreed with the orders passed in. WCA number 28 of 2009, dated 8/1/2013. The insurance company is before this court. It is stated that initially the claimant had filed MVC number.
One submission about this judgment, WC judgment, my lord. This is in Kannada, but only one sentence I will make it translated to the English. At page number 5, my lord. Parties have all second respondent, cross-examination by second respondent. At the fourth page 5, fourth line. ಅಪಘಾತಕದ ಬಗ್ಗೆ MVC ಪ್ರಕರಣ ದಾಖಲು ಮಾಡಿದ್ದು ಅದನ್ನು ವಜಾ ಮಾಡಿಸಿಕೊಂಡಿರುತ್ತೇನೆ ಎಂದು ಅಪಘಾತದಿಂದ ಆಸ್ಪತ್ರೆಗೆ ಹೋಗಿರುತ್ತೆ ಎಂದು ಕೆಲಸ ಆಗೋದು ವೈದ್ಯರು ಯಾವುದೇ ದೃಢೀಕರಣ ಪತ್ರ ನೀಡಿರುವುದಿಲ್ಲವೆಂದು ಲಾರಿಯಲ್ಲಿ ಹಾಗೂ ಚಾಲಕರು ಇದ್ದರೆಂದು ಚಾಲಕನಿಗೆ ಯಾವುದೇ ಗಾಯ ಆಗಿರುವುದೆಂದು ಅಪಘಾತ ದೂರು ನೀಡಿರುವಂತೆ ತಿಳಿಸಿರುತ್ತಾರೆ. He has admitted that he has been with the dismissed for non-prosecution. Dismissed for non-MVC case.
They filed MVC number 540 of 2010 on the file of the Motor Claims Accident Claims Tribunal at Mysore, and the said case came to be dismissed for non-prosecution on
38/2011.
38/2011. 38/2011. Thereafter, this is the present petition is filed. The petition is filed in the Workmen Compensation Act. It is submitted that this fact was also elicited from the cross-examination. When counsel appearing for the insurance company submits that when once an application is filed before the court and that said MVC is dismissed for default, the remedy available to the party is to set aside the said order. But for this very same cause of action, he cannot file the petition under the Workmen Compensation Act. It is submitted that when this aspect was elicited without considering the same, the court had granted the compensation, though notice is served on the respondent. Advocate is there. Advocate is there. Mallappa is.
Yes, ma'am.
Then do one thing. List this matter as part heard tomorrow. Heard the counsel for the appellant in part. No representation for the respondent. List this matter as part heard tomorrow. Tomorrow I'll pass the same
Please,
order.
ma'am.
Serial number 16, M. Venkatesh.
My lord, this is a case by the insurance company on liability, my lord. The injured claimant is another passage in a closed goods auto rickshaw, my lord, which you have insured. Date of accident is on 8/2/2006. Claimant is Ravi, aged about 18 years. Hamali or loader. with the ID.
Lord counsel for the appellant shall file the translated copy by 15th of April. List this matter on 15th. By the time the translated copy is not filed, the appeal shall stand dismissed without further reference to the court. This is an appeal of 2013. Enough time is granted on adjournment of the counsel for the appellant. Yes.
17, Vyasarao KS.
Yes.
I prefer respondent number 3.
Lordship, this is an appeal for enhancement of compensation. Lordship, there is a the
How much is the compensation claimed?
Yes, Your Lordship, it is
20 lakhs.
20 lakhs is claimed.
How much is
5
awarded?
Yes, Your Lordship. 5,47,000 is granted.
5 lakh
47,000
is granted.
7,800.
Any disability?
Yes, Your Lordship. It comes to 47% disability.
What is the disability as per the doctor?
It is 47%, Your Lordship.
To the limb?
Yes, to the whole body.
47%.
2, 3, yes, Your Lordship. There are
Then-
multiple fractures.
Then how much the court had taken?
A court takes, it considers 47% itself, but it does not grant multiplier according to that.
Yes. Multiplier is not granted.
Yes,
What is the
Your
multiplier according to you?
No, sorry. The 47% is the disability as per the doctor. Court takes it as 16%.
That's what, if it is limb,
Yes, Your Lordship.
for the body, it would be with the 1/3 of it. So whether the evidence of the doctor is to the body or to the limb?
To the whole body, Your Lordship.
Is it so?
Yes, Your Lordship.
No.
It's there in the,
Page 10 of the judgment.
yes, Your Lordship.
It's about 7th or 8th line. The disability certificate exhibit P13 shows.
1 minute.
Yes, yes.
Para number?
Page number
Lordship,
10,
page
para
10
number
of-
17 continued in page number 10.
1 minute.
About 7th line.
In page 15 of the appeal.
Seventh line. The disability certificate.
Exhibit P13 shows that the
P13 shows that the
petitioner has
petitioner has disability of 19.17% to the lower limb, 13.05% to the right upper limb.
That is to the limb.
Yes, madam.
Your Lordship,
So,
there are 3 different disabilities to bodies, to the body, and so total it amounts to 47%.
It has to be 1/3. That's a settled law. 1/3 of 47% is what?
Yes, 1/3 of 47% is 16.
That's how it is. Then coming to the income, how much is taken?
12,000 is his income, as we have stated. The employer of the victim is also taken. It says 12,000, but court says because salary certificate is not produced, it is taken as 6,000. Your Lordship, he's
Which year is
professionally.
this accident?
Your Lordship, it's 2012.
It has to be 7,000 then.
Your Lordship,
So
actually,
mere examining the employee is not
employee-
sufficient. He has to produce the register and other relevant
Your
documents.
Lordship, he is professionally a driver. Even, let alone 2012, even today, a driver would not be in a position to produce a salary certificate because they are generally not issued one.
That's not
It
the
is not
argument. That's not the argument. Yes, please come. So, how many of pain and suffering also? How many are the fractures?
75,000.
75,000 is given, Your Lordship. Actually, he has been in hospital for 47 days.
That comes
Then-
under the other head.
No, Your Lordship, because there have been multiple injuries. That's why he had to be in the hospital for so many days. So for pain and agony, 75,000 would be very less. He has suffered multiple surgeries. And the doctor also in his examination, he says that he has to come back and implants have to be inserted. So 50,000 has to be paid more. So 75,000 is too less for pain and agony.
Medical expenses, any dispute on that?
Yes, Your Lordship, 2,40,000 is given. We have produced 50 medical bills. Medical bills are produced, but the court denies those for which we have not produced receipts, although bills have been produced. The discharge summary says that we've been in the hospital for 47 days. So 2.5 lakhs it cannot be the amount that the court could have given.
Yes. How many days was in hospital?
Your Lordship, there are 2 times that he goes to the hospital. One is,
Days.
yes,
Days,
once he goes for
days.
20 days.
Then,
Another time he goes for 25.
is it correct? 45 days.
Yes, ma'am.
2 spells, each will give 45,000.
25 plus 17.
Then loss of income during later period.
Yes, Your Lordship, because the income is taken as less, so the multiplication.
24,000 is granted. The date of accident is 2011, my lord.
19/10/2011.
11. Petition is filed in 2012, but accident is 2011.
2000?
11.
6,500.
Your Lordship, we have examined the employer in this regard. He admits it's 12,000.
No documents have been produced.
Yes, Your Lordship, but that is practically it is not possible for a driver to produce it. Salary certificate is not issued through, there's no certificate for the same. It's not a company.
And he is not a permanent employee also.
What is the multiplier?
The court says 15.
Disability is taken at?
It is 40 days.
16%.
16.
Your Lordship, I will read 2 lines, Your Lordship, regarding disability. I'll read 2 lines that the court says regarding disability. The court says, so it is totally around 47%, whereas it is also true that there is no imputation. Certainly, the doctor might have exaggerated the disability. Lordship, this cannot be an observation regarding the evidence of the doctor because I could not go for any higher level of evidence. The court could not have said that the doctor has.
First of all, understand. Doctor said 47%. 1/3 has to be for the whole body. That is taken.
Yes.
Future medical expenses is for removal of implant.
15,000 is avoided.
What is the evidence of doctor?
Doctor says that he cannot function as a driver.
What is the disability? What are the injuries sustained by him?
Your Lordship, there are the wound certificate may be taken, Your Lordship. It says laceration wound around chin, fracture left tibia, fracture shaft femur right, blunt injury in the abdomen, fracture distal radius, fracture femur shaft left, fracture neck of femur left. Then the wound certificate clearly says,
Doctor. Doctor's evidence.
Wound certificate says 2 to 7 are grievous in nature.
What is the impact on his occupation? Mr. Respondent.
He can carry out his occupation, my lord. The doctor has not stated anything about it.
He's saying so that he cannot do the job of a driver.
He says that doctor, he cannot function
For
as a driver.
17% disability,
No, if it is that said disability
Yes.
is to the limbs,
Yes.
how can he do his duties as a driver? That aspect also has to be.
even the doctor,
No, said so. That's what she's saying. We look at the evidence. Doctor's evidence is
PW3.
examined as
PW3.
in the disability certificate at exhibit P13.
you have the evidence for PW2.
No, my lord.
Give it to him. This in Kannada, please read and tell the court what it is.
I will read.
That also you have taken.
Yes.
File is also there. PW2.
PW2
PW2
is
is the employer, your
employer.
lordship. PW3 is the
Doctor.
doctor.
PW3.
PW3.
Umesh Prabhu.
It's in Kannada or in?
It's in Kannada.
Please read.
ನಾನು ಕಳೆದ 12 ವರ್ಷಗಳಿಂದ ಹೈಟೆಕ್ ಆಸ್ಪತ್ರೆ ಉಡುಪಿಯಲ್ಲಿ ಮೂಳೆ ತಜ್ಞನಾಗಿ ಸೇವೆ ಸಲ್ಲಿಸುತ್ತಿದ್ದೇನೆ. ದಿನಾಂಕ 19/10/21/2011ರಿಂದ ಅರ್ಜಿದಾರನಿಗೆ ಅಪಘಾತ ಗಾಯದ ಹಿನ್ನೆಲೆಯನ್ನು
You can read the relevant and translate it to the court.
ಆತನ ಅಂಗನ್ಯೂನತೆ
You have that. You have the copy.
I do not.
You can also read from that.
ಆತನ ಅಂಗನ್ಯೂನತೆಯ ನಿಶಾನೆ P13ರಲ್ಲಿ ವಿವರಿಸಿರುತ್ತೇನೆ. ಅರ್ಜಿದಾರನಿಗೆ ಇಂದು ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಇರುತ್ತಾರೆ. ಆತನಿಗೆ ಚಾಲನಾವರ್ತಿ ಮುಂದುವರಿಸಲು ಕಷ್ಟವಾಗುತ್ತದೆ. Means it's difficult for him to carry out his profession. That the doctor has not stated that he cannot carry out the profession. With any injuries, it will be.
In these particular cases,
Yes.
where it is, then the disability has to be taken and not at 1/3 when it's going to have an impact on his.
Yes, my lord. The doctor has considered this aspect also, and then has given assessed the disability. It's difficult, but here he says.
No, we can't just take it as a limb disability. It will have an impact.
May be difficult, my lord, but not impossible.
No, in that case,
it's not impossible.
You can't, the usual
because
1/3 we can't apply in this case.
No, the doctor has given the disability, considering this aspect also. He has stated that implants.
It is given. When we are considering
Yes.
the whole body disability,
Yes.
under the facts and circumstances,
Yes.
is it right to take 1/3? It needs to be little more than 1/3. Because his occupation, he is a driver and the whole injury is to both his legs.
And he has stated that the implant, if the implant is removed, his condition will improve. ಅರ್ಜಿದಾರನಿಗೆ ಇಂಪ್ಲಾಂಟ್ ತೆಗೆಯುವ ಶಸ್ತ್ರಚಿಕಿತ್ಸೆ ಬಾಕಿ ಇದೆ. ಇದಕ್ಕೆ ಸುಮಾರು 15,000 ಖರ್ಚು ಬರುತ್ತದೆ. For that, the tribunal has granted future medical expenses.
No, future medicals anyway, in
Yes,
every
yes,
case,
yes.
removal of the implants
Yes.
will be carried.
Yes,
We will, this disability, we will take not 16%, we'll take 25%.
I'll leave it at that.
It is coming to 7,80,000. Please come.
Your Lordship, future medical expenses.
Also granted 30,000.
Your Lordship, there's an implant that has to be done and he has
That
to
is
come back
what
for
is
surgery.
removal of implant is future medical expenses. 30,000 is granted
No,
by this court. The
Interest to be 6%.
6%.
Yes.
Agreed with orders passed in MAC number 168 of 2012 dated 28th November 2013. The claimant is before this court seeking enhancement of the compensation. The claimant had sustained.
Your Lordship, the court had granted me loss of amenities at 15,000.
Loss of
Amenities at 16,000.
I granted it 30,000. That's how you got the enhancement.
Yes, yes.
The pain and suffering 1 lakh is granted. The
Your Lordship, one. He has suffered multiple surgeries, Your Lordship.
That's because whatever it is, it won't be more than that. The as per the wound certificate, the claimant had sustained fracture of left tibia, fractured shaft femur right, blunt injury abdomen, fractured distal radius right, fractured femur shaft left, fractured neck of the femur left. Is aged about 40 years. As per the wound certificate, he was taken inpatient treatment from 19/10/2011 to 5/11/2011. He has underwent surgery of closed IL nailing left tibia and right femur, closed recon nailing left femur, and ORIF distal and radius right with TLCP. Again, he was readmitted on 8/11/2011 to 3/12/2011. At that time, he has underwent physiotherapy. Thereafter, he continued treatment as outpatient. And the court had granted 75,000 towards pain and suffering, and an amount of rupees 2,40,000 was granted towards medical expenses, and towards conveyance nourishment, an amount of rupees 5,000 was granted. And for the removal of implants, an amount of rupees 15,000. And when it comes to the loss of income, the court had considered the income at rupees 6,000 and granted 24,000 per annum, 24,000 for the 4 months period. And towards future loss of income, according to the evidence of the doctor, the claimant had sustained the disability of 19.17% to the lower limb, 13.05% to the right upper limb, and 15.33% to the right lower limb. And it's altogether, he had sustained 47% disability, and court had considered 16% disability and granted an amount of rupees 1,72,800. And towards loss of amenities, an amount of rupees 16,000 is granted. Altogether, an amount of rupees 5,47,800 is granted as per the table given below at page number 16. The
ಸರ್ ಕೋರ್ಟ್ ಹೊಟ್ಟೋಯ್ತು ಅನ್ಸುತ್ತೆ ಸರ್ ಗಾಡಿ ಅವಡಿ ಎರಡೂ ಇಲ್ಲ
for the respondent insurance company submits that the doctor who has examined has given the evidence stating that it is little difficult, but he never said that it is impossible. And once the implants are removed, his situation will be better.
That is not said in the evidence. It is not said that it will become better after removal of implants. This is not something, it's not so.
No, for implants removal, he has stated.
He has said that there are implants, he has to remove it.
Yes.
There is no line in the evidence which says.
No, it's only his contention.
It's
Your Lordship.
implants.
Contention, I'll record your contention also. He
Your
says
Lordship,
that once the implants are removed, he'll be in a little better position. It is submitted that the court had rightly taken 16% and granted the compensation. Even for the pain and agony also, the amount of 75,000 that is granted by the court is on the higher side, and no enhancement is called for. Next para. Having heard the counsels on either side, peruse the material on record. This court has perused the wound certificate and the injuries that are sustained by the claimant. In that view of the matter, and the head of pain and suffering, this court is granting an amount of rupees 1 lakh. Coming to the medical expenses, court had considered the medical bills available on record and granted 2,40,000. And the calculation that is arrived at by the court is a just and reasonable one, and no interference is called for. Coming to the nourishment, conveyance, and attendant charges, considering the 45 days of hospitalization, this court is granting 45,000. Coming to the loss of income during the later period, according to the claimant is earning 12,000, court had taken 6,000. He has examined the employer. No other material is faced. It is argument of the land counsel that it is not possible to place any other evidence in the considered opinion of this court. And the court had rightly not considered the evidence of the employee, and considering that this is an accident of 2011, taking 6,500 as the income. Coming to the disability, he had sustained multiple fractures and particular to the limbs, and as he is a doctor, this court, instead of taking 1/3 as 16, is inclined to take 25,000. So for the loss of income during the later period, 6,500 into 12 into 15 into 25 is 2,92,000. Then coming to the loss of income during the later period, 7 into 4, 6,000 into 4, 6,000 into 5 is 32,500. Considering the injuries to its loss of amenities, this court is granting an amount of rupees 30,000. Future medical expenses for removal of the implants, 30,000. In the light of the law laid down in Mekala versus so-and-so, 10,000 towards legal expenses. Altogether, the claimant is entitled for an amount of rupees 7,80,000. The appeal of the claimant is partly allowed by enhancing the compensation from 5,47,800 to 7,80,000, and the enhanced amount shall carry 6% interest.
Srinivasa KN.
I'm appeal for the appellant in this case. My lord, amend appeal is not filed.
Why not filed? Why not filed? Will impose costs.
Please, my lord, maybe 3 days, maybe 3 days, maybe given a time.
This is matter on
I filed an appeal.
which date?
Your Lordship, I will take LCR copies. I don't have. Please give time.
2014 appeal,
No, no,
whatever.
no.
We'll grant a date on that day, whatever you want to take. This is matter on 3rd of April. By the time the amended copy is not filed, the amended copy of the cause title is not filed, the appeal shall stand dismissed without further reference to the court.
I will apply for copy of kindly order for dispense of law.
You applied, they will give. It is submitted that the counsel of the
I will apply
respondent
today.
has
Because
applied for the
it has come only
TCR
last,
copy.
last
The
Friday.
registration issue the
These
same.
4 years it has not come.
Yes.
19. O Mahesh.
I appear for the appellate. Well, translation may not be required.
Yes.
It's a question of quantum.
You are questioning?
Quantum, my lord, mainly on quantum.
It's a case of death or injury.
Case of a death, my lord, one Mr. Puneet, aged 17 years, a student, said to be earning rupees 6,000 per month, was traveling in the track vehicle, KSRTC bus, dash regulation. Thereby, my lord, the mother and deceased Puneet sustained injuries. Puneet has succumbed to the injuries.
Come to the table.
Terminal, my lord, has taken 5,000 rupees, my lord, notional income.
And which year is the accident?
Of 2009.
Court had taken 5,000.
5,000. Future prospect per lot 2,500 has been added.
It should have been how much?
7,500 my lord is taken and 50% has been deducted and a multiplier of 15 has been adopted to arrive at my lord, total loss of dependency at rupees 6,75,000. 75,000. My lord, in this context, my lord, I would like to invite your worship attention to in page 5, ground number 6, 7, and 8. I'll read, my lord, ground number 6. The tribunal, even otherwise grossly erred in taking the income of the deceased at 5,000 rupees per month in the absence of convincing material evidence and adding 50% towards the future prospect on contrary to the ruling of the larger bench of the Supreme Court of India in Reshma Kumari and others versus Madan Mohan and another, decided on 2nd April 2013, where it has been held that in case where the deceased was self-employed or was not on a fixed salary without provision of any annual increment, the actual income at
Have
the
you
time.
filed any appeal? Have you filed any appeal?
I appear for KSRTC with an insurance coverage. I adopt the argument.
Respondent not filed any appeal. In fact, in the latest judgments, court has been taking. What is he doing? What is he studying?
Student, my lord.
He is in
student.
PCMB. Second year PCMB. Then, my lord, I'll read, my lord, ground 7 and 8. That would be, my lord, relevant for my distinction. The tribunal, when presumed that future prospect of decease should have been equally considered, that he should have, that he would get married in near future, and in such an event, his alleged contribution apart from increment in his income would be reduced to 1/3 instead of 1/2 when being a bachelor. The tribunal further ought to have seen that when multiplier method is employed, things as to on the date of cause of action arose alone should be considered. Ground number 8. The tribunal further failed to notice that and consider the mother of the deceased, who is age group of 35-37 years, claimed her personal income from agriculture operation to a tune of 6,000 per month in her personal injury claim in MBC number for 1324 of 2013. And this evidently proved that she was not dependent on alleged income of her deceased minor son.
Yes.
On these grounds, my lord, the appeal is presented by the insurance company. contribution should have been at 1/3 even on presumption, not as one half.
This also be done.
Mother claimed she had an independent income. So the loss of dependency, my lord, of a minor son who had not employed at all, and take presumption of notional income and adding 50%, my lord, without considering in the near future he would have got married. If so, then even the alleged contribution would be reduced. Therefore, my lord, the compensation requires to be reduced, and rate of interest allowed is 9% instead of 6%.
That will be done.
ಆಯ್ತಾ ಕೇಸು
Mr. Pradeep, what is the judgment where in case of the students, Supreme Court has taken the notional income? There are
Student.
2-3 judgments with regard to the
Student.
who is studying, who is in PUC.
PUC.
There are cases where 10,000 was also taken.
No, as per chat, the year of accident,
No,
Supreme
Supreme Court.
Supreme Court.
In the 2-3
Supreme Court
judgments.
minimum measures has considered in Ayush case and Kajal case.
Mm.
In Ayush case, 10,000 has taken.
Mm. Well, considering the loss of
Future earnings, future earnings. In that case,
Kajal case 10,000, Ayush case?
Ayush case 10,000. Paraplegia. In that case, he has sustained paraplegia. The minimum wages is in a vegetable status. Therefore, the MSCD consider the apex court consider minimum wages of rupees 10,000.
There are like another judgment in the case of BCom. Court had taken Supreme Court had taken 15,000.
15,000. Yes,
where the boy of was studying in
graduation.
BCom first year died. Taken 15,000.
This is not a case of
The
medical
present
student.
petition is fine.
ECMB second year course. Not a medical student.
No, any for BCom special qualification is not required. After PUC, you can join in BCom. Then in that case also.
Presumed to be.
Huh?
Presumed to be.
Presumed to be. That's only can be done. The agreed with the orders passed in. MBC number. What is MBC number? This is
1325.
1325. 1325 2013. The insurance company is before this court questioning the quantum of compensation granted by the court. In a case of death, the court had granted compensation of an amount of rupees at 8,000 to its loss of dependency. Court had considered 5,000 as a notional income. Land counsel appearing for the insurance company submits that as per the judge that the considering the future prospects is contrary to the ruling of the larger bench of the Supreme Court of India in Rashma Kumari versus others, Rashma Kumari and others versus Madan Mohan and others, decided on 2nd April 2013, wherein it has been held that in the cases where the deceased was self-employed or is on a fixed salary without provision for annual increments, the actual income at the time of death without any addition to income for future prospects will be appropriate. It is stated that the tribunal, when presumed about the future prospects of the deceased, should have equally considered that he would get married in near future, and in such an event his alleged contribution apart from increment in his income would be reduced to 1/3 instead of half. That being when being a bachelor. Basing on this, then counsel submits that the court ought not to have granted the compensation. It is submitted that the interest is awarded at 9%, 12%. 12%?
9%.
No, it shows 12%. 9% in the case of death. Granted 9%, which is on the higher side, and that needs to be reduced. Next paragraph. Learned counsel appearing for the respondent KSRTC was also supported the case of the insurance company and submits that the compensation that is awarded by the tribunal is exorbitant. Though notice is served, anybody is representing? There is no representation on behalf of the counsel for the claimant. Next paragraph. Having heard the learned counsels on either side, there is the material on record. The court, while considering the loss of dependency, had considered the income and considered the income.
Respondent number 1 and 2 for
Claimant. Learned counsel.
Kindly pass out the matter, my lord. Senior counsel.
I'm going to dismiss it. Learned counsel appearing for the respondent claimant submits that the tribunal had rightly granted the compensation and no grounds are made out. Next paragraph. Having heard the counsels on either side, there is a material on record. In the light of the law laid down by the Honorable Apex Court, including Kajal, Master Ayush, Kajal, and other in several cases, the court had considered various incomes rating from 10,000 to 13,000 while considering the future loss of income in case of accidents and in case of death. In this case, the student is doing his PUC and considering the future prospects, court had taken an amount of rupees 5,000 as income and granted the compensation. The submission of the insurance, the counsel appearing for the insurance company is not tenable in the light of the latest law laid down by the apex court in several judgments, and this court finds no force in the argument of the counsel with regard with that the future prospects cannot be considered. Next, coming to the rate of interest, court had granted 9,000. This quote is as the uniform rate of interest that is granted is 6%. The court is inclined to reduce the same to 6%. Accordingly, the appeal of the claim insurance company is partly allowed, reducing the compensation from 9% to 6%. The amount in deposit shall be forthwith transferred to the file court.
Please. And amount in deposit to be transferred to MACT.
Yes. Yes, next.
20, GS Venkat Subara.
Appellant in this case, file dispensation in R1, my lord.
Take that.
R2, I will take steps to fresh dismissal. Can you 2 weeks time be granted? R2.
How many years you require?
I will given by trial court advocate, my lord, take instructions, my lord. In the one getting 2 weeks time be granted. I will take fresh address, my lord.
What has happened for the earlier ones?
Earlier also not sufficient address not given, my lord. That also sufficient address not given, my lord.
Then what will you do?
We take fresh paper publication.
Then this is an appeal of 2016.
We take next
Even
week.
Till now, the notice is not served on respondent number 2. Then counsel by the next date of hearing shall come up with an application for substituted service of notice, or else the appeal shall stand dismissed against R2. A memo is filed seeking seeking dispensation of notice to R1. The memo is taken on record and the same is dispensed with at the risk of appellant.
2 weeks time, we'll take steps.
A week's time, not more than that. It's a 2016 matter.
Please,
you can't have your. Yes, next.
21. Prasanna Shetty.
Appearing for appellant, my lords, was kindly pass over the matter.
Yesterday's matter, my lords. It was heard.
My lords, records are not there, my lords. I will go through the records and submit my arguments, my lords. Please.
Hearing on IA.
Great.
Serial number 22. Nagendra Shetty.
I appear for the response in this matter, my lords.
Petitioner in this case, my lord,
Lords,
IA number 1 is a limitation act. IA number 1 filed by the petitioner.
On condition shall be condone the delay.
My lords, they don't even attempt to explain why there is a delay, my lords. On purpose, they get the appeal filed through their grandmother.
Learned counsel, IA number 1016 is filed to condone the delay of 215 days in filing the.
Only IA number 1 is allowed, your mic.
You will not state any reasons, and court will just like that allow. IA number 1016 is filed to condone the delay of 2152 days in filing the appeal. Then counsel will respond in his file his objections and submits that. They have not even stated the basic reasons for the delay, considering the fact that there's an appeal by the claimant and it's a case of death or injury.
Death, my lord. Death.
Death.
And considering that it's a case of death, this court is inclined to condone the delay of 2,152 days on the condition that they are not entitled for interest for the said period. List this matter, TCR to be called for. List this matter after the TCR is called. Yes, next.
23.
IA number 1 of 18 is filed to condone the delay of 7 days. For the reason stated, delay is condoned. List this matter for final hearing. Admit.
Please.
Yes, next.
Admission matter, serial number 24.
For the appellant, my lord.
Yes.
I have filed this appeal for enhancement of compensation. The accident has taken place on 9/6/2009, my lord.
How much is the claim to compensation?
Claim is 8 lakhs rupees, my lord.
How much is granted?
Awarded 1,89,400.
Any disability?
Yes, my lord. There is a disability. But 60% is of both the lower limbs and 30% of whole body.
16%?
60%, 60.
Percent to the whole body.
Yeah, 60% both the bones, both the lower limbs, all the limbs have been fractured, my lord. Here, there is a number of multiple fractures have been sustained by the petitioner.
The whole body disability is?
His whole body disability, as per the doctor, is 30%, my lord.
Court had taken?
Court has taken only 20%.
Income?
Income, my lord, has been taken by the
4,000.
4,000 rupees. It is the accident is on 9/6/2009, 5,000 ought to have been taken.
Please come to the table. Come to the table. Where is
Please
it?
at internal page 17 of the judgment.
Internal page?
17 of the judgment. Bottom, your lordship would find in the bottom.
How many fractures?
He has got 6 fractures, my lords.
This amount is very less.
Yes.
30,000.
Yes.
We'll make it 1 lakh. What is this reimbursement of medical bills?
10,000, the court says the medical bills has been reimbursed, which your lordship would find.
Where is the discussion? Yes, Mr. Lathur, what about these medical bills?
Medical bills.
Are you disputing?
No, no, madam. I am not disputing, madam.
Yes. Then future loss of income. Now coming to the disability, what is your occupation?
He says coolie, my lords. Coolie. He says
Coolie, manual worker.
Both the legs are
yes,
injured.
Yes.
Both the legs, my lord. Yes.
Then in that case, how can we take 1/3?
No, my lord.
Even that is not taken, my lords. Even as per the doctor, the whole body disablement is 30%. The tribunal has taken 20%.
20?
20% has been taken.
We'll take 30% considering the.
Yes.
Then in that case, 5,000 into 12. What is the multiplier?
The multiplier is
Future prospectus may kindly be taken.
We'll consider future prospects also because the case of the when you're taking 30% disability.
No, my lords, because
is a coolie, it will definitely have an impact on his future earning. Both the legs are damaged.
yes, he has got a comminuted fracture of femur, fracture of tibial condyle.
What is his age?
He was aged about
40.
42,
my lord.
42 years.
Then
42.
14 multiplier. Future prospects comes to
25.
1,000. 1,000, my lord. 25% of it.
25%.
$1,250. $6,250 into 12 into 14 is a multiplier.
Yes, my lord.
14 into 30 by 100.
He left 30,000.
It comes to 3 lakh
30,000.
15,000. No? 3 lakh 30,000 it comes.
Yes, ma'am. 6,000.
No, 6,250. 250 into 12 into 14. 30 divided by 100.
Come to 3,15,000.
3,15,000 it comes. Future loss of income. Then what about the hospitalization, other things? No amount is granted. How many days he was in hospital?
My lord,
Attendant, nourishment.
He was
Huh? How many days?
my lord, 20 days, my lord.
Where do you get that?
There is a exhibit P15, my lord. The case sheet of the Spandana Hospital.
You want to see that exhibit or will consider 20 days?
It's not nowhere. There is a discussion about the number of days of
No,
hospital.
this is exhibit P2. Exhibit?
P15.
This here is not there.
P15
What
is a
it
case
says
sheet.
exhibit P15?
It's a case sheet. It's a case sheet. There's no
He says as per that it is 20 days.
discussion even. I don't know. There is no discussion about the number of days of
So with all these injuries, at least it would be. Any future medical expenses as per the doctor?
Yes, both he has to remove future surgery, removal of implants is there from both the legs, my lord. So 1 lakh may kindly be awarded.
Generally, we are awarding 30,000, we'll grant 60,000 for 2 legs.
The doctor was treated. A doctor who was examined has not treated the petitioner.
No, but there are implants, they have to be removed. For both the legs, 60,000.
Loss of amenities may kindly be enhanced, my lord.
How much is granted by the court?
No.
Court is granted.
Nothing is granted.
Not granted. 40,000.
Miscellaneous expenses have not been awarded, my lord. Diet, attendance, and
Now that is considered.
The loss of income during the later period.
15,000 is awarded. For 3 months.
Now we are considering the salary at 5,000.
Yes, my lord.
Court had granted?
3 months, 15,000.
Court has not granted anything.
It has granted, my lords, 15,000.
It's granted?
Yes, yes.
It comes to 5,70,000 from 1,89,400. Please come.
And one submission, my lords. There were 2 vehicles involved.
There
were 2 vehicles involved. No doubt both the vehicles were insured with National Insurance Company. The apportionment is at the ratio of 75% and 25%. So kindly that observation may be
75% on the?
my lord,
75%
it is
on
a
the
case of composite negligence, my lord.
motorcycle.
Need not be apportioned to the liability.
Motorcycle came and dashed the auto rickshaw. The claimant was an inmate of auto rickshaw. The tribunal held 25% on auto rickshaw and 75% on motorcycle. Both the vehicles are insured with National Insurance Company only. But that apportionment may be retained.
25% on
yes.
On the?
25% on insurer of auto rickshaw and 75% 75% on respondent number 2. And
please come to the cost rated.
Yes, my lords.
MFA cost rated.
Yes, my lords.
So 25% on sir, respondent?
Number 2, my lords. And
Hmm.
25% on respondent number 4 and 75% on respondent number 2.
No. 25% on
Respondent number 4,
Ah.
75% on respondent number 2.
Who is respondent number 2?
Both are one and the
No. Which
same.
vehicle?
Respondent number 2 is a insurer of motorcycle.
Motorcycle. And respondent number 4 is insurer of?
Auto rickshaw.
Auto rickshaw.
So far as petitioner is concerned, he can recover against any one of them, my lord. Or all of them. Joint and several liability.
They are one and the same.
Yes, my lord, the same. But
Insurance.
he can recover against any one of them or against all of them. That's because it is a composite negligence.
Correct, Mr. This is this case where both are one insurance company.
Yes, my lord. Yes,
You can recover from them. Agreed with orders passed in MSC number 1290/2011, dated 17th September 2014. The claimant is before this court, seeking enhancement of the compensation. He had sustained, as per the own certificate, he had sustained.
It is at internal page 13 of the judgment, my lords. 13 at the bottom.
He has sustained compound fracture left femoral, fracture tibia, condyle left, fracture patella left, commuted fracture within brackets right femoral condyle, fracture within brackets right tibia condyle, fracture within brackets right patella, underwent OR and IF with patelectomy. As per the evidence of the doctor, he has sustained 60% disability to the both the limbs and 30% to the whole body. According to the claimant, is working as a coolie and earning how much?
4,000.
4,000, my lord.
4,000.
4,000.
Yes, my lords.
According to him, is earning 4,000. In that case, why will we take 5,000? Where is that? Where do you get that?
There is an observation.
And then 4,000 is, we'll take 4,000 only.
That's the observation.
No.
Issue number 5.
PW1 stated that in her cross-examination chief that she's aged about 42 years,
and earning
working
4,000.
as a coolie, earning an amount of rupees 4,000.
4,000.
Then we'll take 4,000. Why 5,000? Then future loss of income, 4,000 plus
25%. That will be
5,000.
5,000.
5,250.
5,000 into 12 into 14 into 30%. It comes to 2,52,000 pounds.
It comes to 2,52,000.
64,000.
5,250.
4,000 into 25% will be 5,000, my lords.
No, 4,000 plus 1,250 is 5,250. Oh, in the future earning, it will also.
25%, it will be 5,000, my lords.
4,000.
Plus 25% will be 5,000.
It is 1,000 only.
Yes, my lords. It comes to 2,52,000.
1,000. It comes to 5,000.
5,000 into 12 into 14. 30% of it will be 2,52,000. 52,000.
52,000. Out of that, minus 3,15,000 is
Loss of amenities may kindly be enhanced. Further, Lifelong she has to suffer with that disability.
It comes to 5,07,000. 5,07,000 it comes.
Yes.
Minus 63,000. 5,07,000. If you deduct from that amount which is arrived earlier.
Yes, ma'am.
What did you write? 4,000 per month. Court had taken the same.
Court had taken 4,000, whatever that is being set out.
And court had
Your
taken
lordship would find that
4,000.
internal 70.
And the disability was taken at 20%.
Yes, my lords.
Disability was taken at 20% and granted the loss of future income at 1,34,400. And for the loss of income during the later period, 15,000 is granted. Towards pain and suffering, 30,000. Reimbursement of medical bills, 10,000. Put together, an amount of rupees 1,89,400 is granted by the tribunal. When it comes to the liability, the court has held that respondent number 1 is the RC holder of the motorcycle. Respondent number 3 is the RC holder of the auto rickshaw. Respondent number 2 and 4 are the insurer of both the vehicles. Due to the Contributory Negligence Act of the right of the motorcycle is 75%. And the contributory negligence of the auto rickshaw is 25%. Accordingly, the policy is in existence. Therefore, respondent number 1 and 2 are jointly and severally liable to the compensation on 70%. Respondent number 3 violated the terms and conditions of the policy. Therefore, the respondent number 4 is who?
My lord, respondent number 4 is the insurer of auto rickshaw.
But then it says it is not liable to pay.
No.
Both of you are not saying that. Yes. Look at the page number, internal page 18.
Owner has been fastened with the 25%. I'm sorry, my lords, because I didn't have a record.
Therefore, the respondent number 4 is not liable to pay 20% of the compensation in support of the auto rickshaw. What is the violation of the conditions?
Permit.
Thereby, the owner of the auto rickshaw is liable to pay. No, in that case, violation of the permit conditions, no pay and recover in that. You have to pay. Isn't it?
Yes, my lord.
Therefore, the respondent number 4 is not liable to pay 25% of compensation in support of the auto rickshaw. Hence, the court held that the owner of the auto rickshaw is liable to pay 25% of the compensation. And the insurer of the motorbike is liable to pay compensation of an amount of 75%. Agreed thereby, the claimant is before this court. The counsel appearing for the claimant submits that for the injuries sustained by
But
the
in the
claimant.
operative portion, it is said respondent number 4 has to pay. So that's why I got confused, my lord. The operative portion of the judgment, it is said insurer of auto rickshaw has to pay that 25%.
But in the
yes, there is no, yes, there is an ambiguity because if your lordship finds at the operative portion of the order, second paragraph,
respondent number 2
insurer
is
of
the
auto
insurer
rickshaw,
of the motorcycle, deposits 75% of the.
Yes.
No, it is respondent 4 is the owner.
No, but, oh my lord,
It's
respondent
a-
number 4 is the insurer of auto rickshaw.
No. If you come in violated the terms and conditions, therefore respondent number 4 is not liable to pay.
In the operative portion.
I'll discuss it.
In the operative portion, it is said respondent number 4, insurer of auto rickshaw, has to deposit 25%.
Actually, typographical mistake is in the order, operative portion. Because they've given a discussion why not liable.
Finding and order are conflicting with each other.
What did you write? Government submits that on all the counts, the compensation that is granted by the tribunal is not a reasonable one, and then the same needs to be enhanced. It is submitted that the owner of the insurer of the auto is also liable to pay the compensation, and violation not having the permit cannot be a ground to exonerate the insurance company. Then coming to the land counsel appearing for the insurance company submits that the court had rightly held that the insurance company is not liable to, or the insurance company of the auto is not liable to pay the compensation, and it's alone who is liable to pay. It is submitted that the compensation that is awarded by the tribunal is just and reasonable, and no interference is called for. Next para. Having heard the counsels, there is a material on record. This court had perused the order and the material wherefrom the claimant had sustained as many as 6 fractures. Considering the same, this court is granting an amount of rupees 1 lakh towards pain and suffering. As far as the medical bills are concerned, there is no dispute on that. Coming to the income, according to the claimant, is earning 4,000. The court had taken 4,000. The disability, she has sustained disability to both the limbs, and according to the doctor is 30%, and she is a coolie, and the court had taken 20%, and this court is inclined to take it as 30%. In that case, and considering her occupation, in this case, she is entitled to the future prospects also. 4,000 plus 25% of the future prospects will come to 1,000. That becomes 5,000. 5,000 into 12 into 14 into 30 by 100 is 2,52,000. And for towards loss of income, this court is awarding an amount. Let it be this court is granting an amount of rupees 15,000 towards attendant nourishment for the 20 year as per exhibit P6. Is it so?
P6 case sheet.
P6 is in hospital for 20 days. Towards that attendant and nourishment, 20,000 is granted. Future medical expenses, there are 2 implants in both the legs
P15
that needs to be removed.
It's P15. P15.
Exhibit P15 that needs to be removed. Hence, towards future medical expenses, 60,000 this court is granted. Loss of amenities, considering the disability, 40,000. And in the light of the law laid down in Mekala, legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 5,07,000. Accordingly, the 5,07,000. This court has perused the order of the trial court, where at one stretch it is stated that the owner of the vehicle, owner of the auto, is liable to pay the compensation. When it comes to the operative portion, it says insurer of the auto are liable to pay the compensation. Even otherwise, whatever is the violation that is stated, still the insurance company is liable to pay the compensation. The court had fixed the liability at 25% on the insurer of the auto and 75% on the insurer of the motorcycle. Accordingly, and the same is affirmed. Accordingly, the appeal of both the insurance companies are one and the same. Accordingly, the appeal is partly allowed, enhancing the compensation from 1,89,4,400 to 5,00,000 and the enhanced 6% interest, which is payable by the respondent number 4 shall pay 25% of the compensation, and respondent number 2 shall pay 75% of the compensation. And any delay?
There is.
Delay condoned, my lord, on 3/2/21.
Delay in filing is condoned.
Yes, my lord. Yes, my lord.
Without condition or with condition?
Without condition.
Yes.
With your lordship's kindly, I may be given a liberty to recover the amount as far as the insurer of auto rickshaw is concerned. because there is a violation of permit, my lords. Based on that finding only, tribunal held that the owner has to pay. Have led in the evidence of RW1 and RW2, saying that he has plied the vehicle.
The law on the
It's
permit violation.
It's a pain recovery. I may be given liberty because earlier.
No, in which judgment it is said with regard to the permit?
My lords?
With regard to the permit.
There is a judgment, Rani versus National Insurance Company, wherein which Apex Court has held that. I would produce it at 2:30.
Afternoon.
Yes,
Then we'll
yes,
say
yes.
pay and recover.
Because that earlier the liability was fastened on the owner. Now in view of, I have been directed to deposit.
The judgment.
Yes, my lords.
Yes. Yes, afternoon. Same continuation with that.
At least serial number 11. Afternoon, I have one case before the mediation center, my lord. I may not be able to attend here.
What is the number?
Serial number 11, my lord. 7067 of 2014. Day after tomorrow, my lord. In list 3, my lord.
And no mentions now. All of you don't make mentions.
I'm sorry, my lord.
Heaven is 2014 matter.
Yes, my lord. Afternoon, I have a case before the mediation
Tomorrow.
center.
Let it come tomorrow.
Oh.
Yes.
Your lordship leave, my lord.
Your lordship is smart. No, please don't make mentions. Yes.
With your lordship leave, my lord. Serial number 30, admission.
No mentions at 1:30, Mr. Mahesh. Yes.
Please.
Any signatures?
ಅದು ಅಲ್ಲಿ ಅಲ್ಲೋ ಮಾಡಿದ್ರು ಜಜ್ಮೆಂಟ್ ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿ ಕಂಟಿನ್ಯೂಷನ್ ಅದನ್ನ ಹಾಕ್ಬೇಕು ಅಂತ
ಮ್ಯಾಮ್ ಇದು ಲಿಸ್ಟ್ 2 ಯಾವಾಗ ಕರೀತೀವಿ?
ಲಿಸ್ಟ್ ಇದು 1 ಆದ್ಮೇಲೆ ಮೇಡಮ್
ಇವಾಗ್ಲೇನಾ?
ಮೇಡಮ್ ಮಧ್ಯಾಹ್ನ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ ಲಿಸ್ಟ್ 2 ತಗೋತಾರ
ಕಂಟಿನ್ಯೂ ಮಾಡಿ ಅಂದ್ರೆ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತೀನಿ. ಪಾಸ್ ಓವರ್ಸ್ ಇದೆ
ಆಮೇಲೆ ಲಿಸ್ಟ್ 2 ತಗೊಳ್ಳೋದಾ?
ಪಾಸ್ ಓವರ್ ಆದ್ಮೇಲೆ
ಗೊತ್ತಿಲ್ಲ. ಅದೇ ಪಾಸ್ ಓವರ್ ಫಸ್ಟ್ ಕಂಟಿನ್ಯೂನಾ ಗೊತ್ತಾಗುತ್ತೆ.
ಒಟ್ನಲ್ಲಿ ಲಿಸ್ಟ್ 2 ಮಾತ್ರ ಕರೆಯಲ್ಲ,
ಕರಿತೀವಿ
ಅಂದ್ರೆ ಸ್ಟಾರ್ಟಿಂಗ್ ಕರೆಯಲ್ಲ ಅಂತ.
ಸ್ಟಾರ್ಟಿಂಗ್ ಕರೆಯಲ್ಲ, ಪಾಸ್ ಓವರ್ ಕರಿತೀವಿ, ಇಲ್ಲಾಂದ್ರೆ ಕಂಟಿನ್ಯೂ ಲಿಸ್ಟ್
ಬಂದು ಕೂತ್ಕೊಂಡ್ಮೇಲೆ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಕರೀರಿ ಅಂದ್ರೆ ಅವ್ರೇನ್ ಮಾಡ್ತಾರೆ?
ಅಲ್ಲ ಅವ್ರಿಗೆ ಗೊತ್ತಲ್ಲ, ಅಕಸ್ಮಾತ್ ನಂಗೊಂದು ಸ್ಟೇಟ್ ಕಮಿಷನ್ ಅಲ್ಲೂ ಬೆಳಗಾಂ ಮ್ಯಾಟ್ರು ಎಕ್ಸ್ಟೆನ್ಷನ್ಗೆ ಹಾಕ್ಬೇಕು, ಹಂಗಾಗಿ ಅದಕ್ಕೆ ಕೇಳ್ಕೊಂಡೆ. ಹೌದಾ? 2:30 ಕೂತ್ಕೋತಾರೆ ಅಂತ ಅಂದ್ರು, ಬೆಳಗ್ಗೆ ಕೇಳ್ಕೊಂಬಂದೆ. ಅದಕ್ಕೋಸ್ಕರ ಆಮೇಲೆ ಕರಿತೀನಿ. ಇಷ್ಟು
ನೆನ್ನೆ ಅಂತ ಎಲ್ಲ ರೀಚ್
ಮೇಡಮ್ ಅವರೇ, ನಂಗೆ ಲಿಸ್ಟ್ 3 ಸೀರಿಯಲ್ ನಂಬರ್ 2 TCR ಬಂದಿದೆಯಾ ಅದರಲ್ಲಿ ರಿವ್ಯೂದು ಅಂತ ಕೇಳ್ಬೇಕು. ಜೋಶಿ ಸಾಹೇಬ್ರು ಅದೇ ಇಂಪಾರ್ಟೆಂಟ್
ಇದೆ,
ರಿವ್ಯೂದು ಬಂತ ಅಂತ ಅದೊಂಚೂರು ಕೊಟ್ಬಿಟ್ರೆ ಇಬ್ರು ಇದೀವಿ, ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಕ್ಲೋಸ್ ಮಾಡ್ಕೊಂಡ್ಬಿಡ್ತೀವಿ. ಅಲ್ಲಿ ಮಾಡಬೇಕು. ಹಾ ಎಸ್ ರಿವ್ಯೂ ಕೊಡಿ ಮೇಡಮ್. ಒಂದೇ ನಿಮಿಷ ನಾವು ಕೊಟ್ಬಿಟ್ಟು ಇಲ್ಲ ಇಬ್ರು ಇದೀವಿ ಮೇಡಮ್, ಅದು ಕೊಡಿ ಮೇಡಮ್, ಅದೇ ಇಂಪಾರ್ಟೆಂಟ್. ಎಲ್ಲೂ ಹೋಗಲ್ಲ ನೀವು ಅಷ್ಟೇ ರೀ, ಎಲ್ಲೂ ಹೋಗ್ಬೇಡಿ, ಕೂತ್ಕೊಳ್ಳಿ. 30 ಎಷ್ಟು ಬೇಕು
ಅದ್ರಲ್ಲಿ ಯಾವ್ದು ಇಲ್ಲ, ಈಗ 2 ಸೈನ್ ಆಯ್ತಲ್ಲ ಅದೇ.
ರೆಕಾರ್ಡ್ಸ್ ಗೊತ್ತಾ? ಹೌದಪ್ಪ ನೆನ್ನೆದ
ಓನರ್ ಈಗ ಇದ
ಸರಿ ಯಾವ್ದಾದ್ರು ಮಾಡಕ್ಕಿದ್ಯಾ ಇನ್ನೂನು ಕರಿತೀನಿ ಅವಾಗ ಹೇಳಿ ಮೇಡಮ್ ಕರಿತೀವಿ ಮಧ್ಯಾಹ್ನ ಕರಿತೀವಿ
ಇದೆಲ್ಲ ಏನು ಇಲ್ಲ ರೀ
ಅದ್ ಗೊತ್ತಿಲ್ಲ ಅದ್ ಹೇಳ್ದಾಗ
ಏನಿಲ್ರಿ ಇದ್ರಲ್ಲಿ.
ಇಷ್ಟು ಒನ್
ಕೋಟ ಹತ್ರ ಬರ್ತಾಯಿದ್ದೀನಿ ಅಲ್ಲಿ ಹತ್ರ ಬರ್ತೀನಿ ಬಾ
ಇದೆಯಾ?
ಇಲ್ಲ ಡಿಸ್ಮಿಸಲ್ಗೆ ಆಗ್ತಾರೆ
Yes.
ಎಲ್ಲಿ
ಇವನು ಕೂಡ
ಹೇಳಪ್ಪ
ಹಾ
ಇದು ಯಾರು ಇವ್ರಿಗೆ ಯಾಕೆ ಅಪಲೆಂಟಿಗೆ
ಇದರಲ್ಲಿ ಯಾವಾಗ ಕೊಟ್ಟಿದ್ರು ನೋಡಿ ಅವನೇ ಕೊಟ್ಟಿದ್ದು
ಗೊತ್ತಿಲ್ಲ ಮೇಡಮ್ ನೀವು ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ರೆ ಏನ್ ಮಾಡ್ತೀರಾ ಇರ್ಬೇಕು ನೀವು
ಅಲ್ಲ
ಇದ್ದು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಕೊಂಡು ಕೇಳ್ಕೊಂಡು
MSL ಕೊಟ್ಟಿರೋರು ಎಕ್ಸಿಬಿಟ್ ಆರ್ಟ್ ಟ್ರಾನ್ಸ್ಪೋರ್ಟ್ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಅವರಿಗೆ 36-10-2015 ಓಕೆನಾ 30-10-15 36-98 ಫಸ್ಟ್ ಟೈಮ್ ಅಂದ್ಬಿಟ್ಟು ಇದ್ರಿ ಕೊಟ್ಟಿದ್ದು ಫುಡ್ ಕ್ಯಾರಿಯರ್ 4 ಮೀಟರ್ ಮತ್ತೆ ಇನ್ನೇನಿದೆ ನಿಮ್ದೇನು ನಿಮ್ಮೂರು ಅದೇ ಆಫೀಸರ್ಸ್ ಆಫ್ ದಿ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಅಷ್ಟೇ ಮಾಡಿದ್ದಾರೆ ಹೌದು ಮಾಡಿದ್ದಾರೆ ಚಂದ್ರಶೇಖರ್ ರೆಡ್ಡಿನ ಚಂದ್ರಶೇಖರ್ ಎವಿಡೆನ್ಸ್ ಇದೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್ ಬೈ ದೆಮ್ ಏನು ಮಾಡಿಲ್ಲ ನೋಡಿ ಅವನು ಕಾಪಿ ಆಫ್ ಇನ್ಶೂರೆನ್ಸ್ ಪಾಲಿಸಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಷ್ಟೇ ಯಾರು ಇವನೇ ಕೊಟ್ಟಿದ್ದಾರೆ ಹೌದು ನಿಮ್ದು ಕಾಪಿ ಆಫ್ ಇನ್ಶೂರೆನ್ಸ್ ಪಾಲಿಸಿ ಅಷ್ಟೇ
ಗೊತ್ತಿಲ್ಲ ನೋಡೋಣ
ನಿಮ್ಮವ್ರ ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಟ್ಟಿರೋದು ಅಷ್ಟೇ ಓನರ್ ಮಾಡಿದ್ದಾನೆ ಸರ್ಟಿಫಿಕೇಟ್ ಮಾಡಿದ್ದಾನೆ ಡ್ರೈವಿಂಗ್ ಲೈಸೆನ್ಸ್ ಕೊಟ್ಟಿದ್ದಾನೆ ಅಷ್ಟೇ ಇದು ಕೂಡ ಅವರೇ ಕೊಟ್ಟರು ಏನೋ ಪಾಲಿಸಿನ ಯಾರು ಕೊಡ್ತಾರೆ ಹಂಗ ನಿಮ್ಮವ್ರು ಏನೂ ಕೊಟ್ಟೇ ಇಲ್ಲ ಬರೀ ಅಷ್ಟೇ ಯಾಕಂದ್ರೆ ಮಾತಾಡಿಲ್ಲ ಯಾವುದು ಪಾಲಿಸಿನ ಯಾವುದು ಮಾತಾಡಿಲ್ಲ ಪಾಲಿಸಿ ಮಾತಾಡಿ
ಸರ್ ಕೋರ್ಟ್ ಕೇಳಿಸ್ತಿದ್ಯಾ?
ಕೇಳಿಸ್ತಿಲ್ಲ. Audio of the court is muted, my lords.
Even here also pay and recovery order has been passed, my lords. And the tribunal has already accepted my contention that there is a violation of permit. That's the reason the liability was fastened on the owner as far as the auto rickshaw is concerned. Now your lordship having held that I am liable for payment of compensation, a liberty has to be given to me to recover the compensation from the owner of the auto rickshaw, my lords. Because I have adduced evidence in support of the contentions urged by the insurance company.
Yes, there are no judgments contrary to this.
No, my lords.
Yes, Mr. There are no judgments contrary to with regard to the permit.
Thani is the latest one.
Somehow like I remember that I've come across a judgment. That's why I'm little hesitant on granting this. There was a distinction between like in case of pay and recover, whether it is the substantial violation of the terms and conditions, whether the permit amounts to that. There was an elaborate discussion in one of the judgments I saw.
Because why I remember this judgment, as I said, I conducted this matter and before the tribunal during my initial race. So I remember it's a case of route permit and it is being followed by this honorable court, my lord, in several other judgments.
Thani has been followed.
It's been followed, my lords. Yes,
Because, you know, once
yes, yes. I would give other judgments wherein which Rani is followed. Yes, yes, my
for
lord.
judgment. Yes, next. Top of the list tomorrow. Give the password. Call the password.
That it may kindly be taken up
This
by
one
the
is case, my
Thursday
lord.
on Friday.
Kindly may I have from,
Pradeep has left. He has got some inconvenience.
kindly may I have from Thursday, my lord. I'm ready with the matter, my
Passed
lord.
away.
Wednesday.
Yes, much obliged.
Yes. This also Wednesday.
For the respondent number 4.
Yes. You're ready with 6 or
No,
6?
my
Or
lord, it may be taken up. Liability
Wednesday.
issues then.
No representation for the appellant, even on the last occasion and even today also. List this matter under the same caption on Wednesday. Yes. Wednesday is, what is today? Next Wednesday. Then which is the one? Next password? 9.
9,
Yes.
I am
Yes.
for the
Mm.
in both these matters. They are misrepresented claims. The rider of the motorcycle has dashed against a roadside culvert, resulting in injuries to him and death of the pillion rider.
Give the file. Insurance company is questioning the liability or the quantum?
Liability, my lord.
Liability. On the ground that?
Liability. Misrepresented claim. Fraudulently tractor trailer insured with me is implicated in the records.
Please come to the particular finding with regard to the liability. We'll read from para number 13. There are 2 MBCs, which on both MBCs you have filed appeal.
Yes.
Yes.
Para 14 would be relevant. The petitioners have produced the police records. As per FIR, the accident took place on 17/5/2013. The jurisdiction police station has received the first information report on 18/5/2013. On the report of second petitioner in MVC 131 of 2013, registered the accident case against first respondent. The investigating officer visited the spot, drawn the measure, seized both the vehicles through measure, drawn the inquest measure, and sent the requisition to motor vehicle inspector. The motor vehicle inspector has inspected both the vehicles and submitted his report. According to the motor vehicle's accident report, the motorcycle was damaged, but the tractor trailer was not damaged. However, the accident is not occurred due to any mechanical defect. The rider of the motorbike, Aruswamy alias Eris Swami, has sustained simple and grievous injuries as per wound certificate at Exhibit P9. The investigating officer, after receiving postmortem report and wound certificate of Aruswamy alias Eris Swami, submitted final report against the first respondent. The document produced by the results speak that the accident occurred due to rash and negligent driving of the tractor trailer. This is the finding I am questioning. Lords, kindly take to page 5 of appeal memo. Ground number 2. Chronologically, I have culled out the fatal aspects of the errors in the judgment of the tribunal. Could my lords get clarity? The accident occurred at 9:30 p.m. on 17/5/2013, and FIR is prepared on the next day at 1:30 p.m. for the instance of one Parashurama who was not examined before the tribunal. My appeal memo, my lord, ground number 2.
Yes, I'm looking at it.
The complainant had stated that a water tanker had dashed against the motorcycle, not tractor trailer. But the insured TT unit is not a water tanker. The inquest Panchanama prepared on 18/5/2013 had been drawn referring to some unknown vehicle. Let's kindly see. On 18/5, when the inquest was drawn, unknown vehicle is shown, not a tractor trailer unit. The IMV report dated 15/6/2013 at Exhibit P6 shows damages only to the front portion of the motorcycle, and IMV report of the TT unit dated 17/7/2013 does not even show a scratch or damage to any portion of the said vehicle. Third, the spot sketch marked at Exhibit P7 clearly shows that motorcycle had dashed against the culvert on the road, which only substantiated the damages caused to the motorcycle as a consequence of dashing against a culvert by the motorcycle without involvement of tractor trailer unit. Exhibit P6 is the IMV report, correct? The nature of damages that could be caused to a two-wheeler when it dashes against a stone masonry culvert is apparent. The input TT unit is produced by the owner along with driver on 16/7/2013 before police voluntarily. Kindly see this. After 1 month, TT unit is produced by the owner before the police voluntarily along with driver.
Mr. Sitaramara, whenever it is possible to you to appear physically, we'll hear this matter. When do you want?
My lord, driver of the vehicle is already convicted by the trial court, my lord.
On plea of guilt.
Yes.
Sir, you pay penalty, they will plead.
When do you want?
Thursday.
Yes, Thursday. Thursday.
Thursday, some person will get my lord Friday. After 27th.
What is that?
After 27th, any date may be given.
List on 3rd.
Okay.
Yes, next.
Appear for appellant, my lord.
Yes.
Case of injury, my lord. Claim petition is dismissed on the ground that there is a delay of 4 days in lodging complaint. Delay, stating that delay is properly explained.
Please come to the order and please come to the exhibits.
In FIR itself,
No, come to the exhibits. What are the exhibits that are marked? To the index, come to the annexures.
FIR,
Major sketch.
Mazar, sketch, charge sheet.
Wound certificate is dated?
Yeah, same date. On the same day was it shifted to the hospital. After investigation, police, thorough investigation, police have filed a charge sheet against the
No
offending.
MLC extract.
Wound certificate is produced.
Why not MLC extract?
This MLC extract is not produced.
It should be, that's because when there is a delay and when the other side is denying
for-
the accident,
For
it should
delay,
have been the first document.
there is for the delay, there is a specific clarification, my lord.
No, that is one. That is one. And apart from that, and if you can substantiate your case by filing the MLC extract.
If the matter is demanded, I can be.
No, but court doesn't have to advise you. You should have done by this time. At the time when you are supposed to do. Court was right in dismissing it.
For the
First given you the wound certificate, which hospital is that? Is it a private hospital?
Sairam Hospital, private. Immediately after the accident, he was shifted to nearby hospital. He was in.
Any day they can give that certificate. But if the MLC extract is there, then it will support your case. Anybody examined, any doctor examined in support of your hospitalization and your treatment in the hospital?
Subsequently was shifted to some other hospital. I have examined the treated doctor.
What is relevant is that
In the
first hospital.
First hospital doctor is not examined. I may be matter
Not at
request
this
for
time,
the
not at
remand.
this time. Please come.
Regarding delay, the specific explanation is there.
That we will not, that we will, in spite of considering that, but you have, unless and until these documents and these witnesses are there, court cannot be believed. Agreed with orders passed in.
If the matter is demanded, I can examine the doctor and also I can
2015,
produce the
10 years
MLC
back,
extract.
agreed with orders passed in MVC number 571 of 2015, dated 18th December 2015, whereby the claim petition is dismissed. The claimant is before this court. It is a case of the claimant that on 2/1/2015 at about 4 p.m., when the claimant was proceeding on Activa Honda on the left side of Kankapura Main Road, at the time, one tractor trailer driven by his driver came in a rash and negligent manner and dashed against the vehicle. Due to the impact, he fell down and sustained grievous injuries to his right chest and right shoulder. Immediately after the accident, he was shifted to Sairam Hospital, wherein he took treatment for 1 day as an inpatient and then shifted to SGARC Hospital and was admitted as an inpatient and underwent surgery. And he was discharged with an advice not to involve in any physical strain for a period of minimum 6 months. The insurance company has resisted the said claim, and it is their case that the accident, the complaint is given after 1 day after the accident.
4 days.
4 days.
Days after the accident. No delay, however, the reasons for the same are not forthcoming. The court had dismissed the claim petition on the ground that what made the PW3 not to lodge the complaint for 4 days, there is no explanation. All the factors create doubt in the mind of the court to believe the version of PW1 and 3. The document also not suppose the case of the claimant. The tractor was involved in the accident. Reasons assigned in the complaint are not satisfactory to come to the conclusion the tractor was involved in the accident.
And it's a case of self-fall.
And the IMB report also not placed before the court. Hence, the court do not find any material before the court to come to the conclusion that the tractor was involved in the accident. And mere filing of the charge sheet is not enough to come to the conclusion that tractor was involved in the accident. And the court also observed that it's a duty of the claimant to place material before the court to prove that the tractor was involved in the accident. Both in the written statement as well as in the evidence, specifically the insurance company specifically disputed the very involvement of the tractor in the accident and categorically suggested that in collusion with the insured, the police falsely implicated the tractor, and accordingly court had dismissed the claim petition. Then counsel appearing for the claimant submits that in the complaint they have satisfactorily explained the delay. Mere delay in giving the complaint cannot be a reason to disentitle the claimant from claiming the compensation. It is stated that the court had failed to consider the both oral and documentary evidence that is placed before the court, and without appreciating the evidence had dismissed the claim petition. Next para. Then counsel appearing for the respondent insurance company submits that when the petition is filed under 166, the burden lies on the claimant to prove the same. When the complaint is given with a delay, the medical records that were placed before the court do not support the case. Particularly, the MLC register extract was not placed before the court, and nobody is examined on behalf of or examined from Sairam Hospital, who had treated the petitioner, as he has failed to prove that the accident has happened. The court had rightly dismissed the petition, and there are no grounds to interfere with the order passed by the tribunal. Next para. Having heard the counsels on either side, peruse the material on record. The accident has taken place on 17/5/2013. 4 days thereafter, the complaint is registered. It is a case that immediately after the accident, he was admitted in Sairam Hospital. Near the MLC.
2/1/2015. 2/1 accident is on 2/1/2015.
Date of accident.
Date of accident is?
2/1/2015.
Date of accident is 2/1/2015. And the complaint is given 4 days thereafter. He has, when he was admitted in Sairam Hospital, he has not placed before the court the MLC extract, or he has not examined anybody from the hospital to substantiate his claim that he has sustained the injuries in the road accident. He is relying on the wound certificate and the discharge summary by which hospital?
This wound certificate issued by the Sairam Hospital.
Sairam Hospital.
Discharge summary is issued by the Sanjay Gandhi.
SVARC Hospital. Basing on this, the relying on this, the claimant submits that the accident had taken place. This court, the place, if the petitioner immediately after the accident, he was admitted in Sairam Hospital, the claimant ought to have filed the MLC extract, or he should have examined the doctors to show that he was admitted in the said hospital, except marking exhibit P5. He has not examined any doctor in support of his case. Though it is stated that there is explanation with regard to the delay, the first document, that is the medical documents, which prove the accident and the admission in the hospital, in that regard, the petitioner had not adduced sufficient evidence. Land counsel submits that if the matter is remanded, he would adduce evidence. He would mark the said documents. This MVC is of the year 2015, and in 2025, there is no purpose to be served in remanding the matter. In that year of the matter, this court finds no reasons to interfere. Dismiss. Next. Yes.
Serious appeal, my lord. Petition filed under 163A.
On what ground you filed the appeal?
Vehicle is not involved in the accident.
For that, come to the finding of the court.
Please.
Page number.
Para 11, page 8. The next witness, shall I read, my lord? The next witness for petition PW Deepak Rai, who has lodged a complaint in respect of said accident, and he has stated that the deceased was a pillion rider. One Praveen was the rider. He also stated as to how the accident occurred and deceased succumbed to the injuries. In the cross-examination, he has stated that he is a BA graduate. He is now presently working as a sales executive in ICICI Bank. He has stated that Suraj is not his relative, nor PW1 is his relative. It was suggested that the deceased was drove the motorcycle bearing number KA19R4754 and dashed to the pole, sustained injuries. He has denied it. Some citations were made to him and he has denied. The learned counsel respondent has argued that this witness has not supported the prosecution case before the criminal court, has confronted his deposition before the court, but such confrontation will not help the respondent in any way, because it is their case that the deceased was riding a vehicle number 4754. It is not at all their case in the return statement. So making citation without there being any pleadings will not help the respondent. Even apart from this, I have perused exhibit R1 before the JMFC court. He has admitted his signature in exhibit P1, but he has stated that he has not seen the accident. This has to be noted, my lord. In the subsequent cross-examination of the prosecution, it is evident that para 3 he has admitted that himself and Harsha and Praveen took Suraj and all admitted the deceased to hospital. He also came to know that deceased succumbed to injuries in the
Also
hospital.
to be noted.
My lordship?
This also to be noted.
No. Which hospital? They have not even produced the MLC record, my lord. Please come to the same Deepak Rai lodged 2 FIRs on the same day and the same crime number was registered by the police. Kindly come to exhibit P1.
I will complete this.
Let me complete, my lord. He has admitted in signature in exhibit 2 Mahajar. So this witness has admitted before the court regarding taking the decision and his signature on exhibit P2. He is an educated person. Before the criminal court, he has not supported the prosecution, but it is evident from before the court that complaint bears his signature. He himself has taken the deceased to the hospital along with the others. So unless he was present at the spot of the accident, he cannot take the deceased to the hospital. Therefore, simply because that witness has not supported the prosecution regarding giving evidence against the accused in criminal case, that does not mean that his evidence before the tribunal cannot be believed. This is how the learned judge. Next, come to para 14, page 11, my lord. So, in view of the principle.
Para 13 also.
Please 13 also. Again, as this respondent got examined one Pratibha Shetty, administrative officer NIC, Mangalore as RW1. In her examination, RW1 has stated that a false case has been made stating that deceased was a pillion rider of motorcycle 7088. She also produced documents that certify of a deposition of Deepak Rai. I have already discussed about the value of the said exhibit R1. Respondent also produced certificate copy of the judgment passed in CC number so and so, wherein the accused was acquitted as the witness have not supported the prosecution case. The respondent have produced certificate copy of the plea of exhibit R3 recorded in the criminal case, but the document will not help the respondent in any way, because it is the settled principle of law that findings of a crime has no bearing while considering the evidence before the tribunal. In this regard, so and so judgment was mentioned. Come to para 14, my lord. Then. So, in view of the principle stated above, the documents of the respondent are no use at this stage. The next document produced by the respondent is exhibit R4. That is information accompanying the body sent to postmortem, for which it indicates that said information received on 1106 at 1:30 p.m. by Dr. Jayaprakasha, that is exhibit R5, is the receipt regarding the same. They have produced one more document stated to be the FIR typed copy in FIR number 1 of 06, According to respondent, as per this document, Suraj drove the vehicle bearing number KA19R 4754. The same Deepak Rai lodged two complaints stating that one vehicle 788 which was insured by me, he was driving. Next, in the second FIR, he stated that 4754 is the vehicle that is involved in the accident. There is no MLC produced. All this collusion with the claimants and insured, my lord, they have not even made IMV report. They have not seized any one of the vehicles. Fraud is committed on the court, my lord, which was not noticed by the learned MACT. Come to next page, my lord, page number 13. Continuation of this. Right from page number 12, last 5 sentences, my lord. Said document is requisition of furnishing post-mortem report, and this document is produced by the respondent themselves. Nowhere the vehicle KA19 4754 is mentioned. So producing such documents will not help the respondent in any way to show that this was rider of the said vehicle. Said vehicle was involved in the accident. On the other hand, at para 2 of the written statement, they have themselves clearly stated pillion rider and Praveen was rider of motorcycle so and so. Next, after 5 sentences, my lord. Also pertinent to note that in our chief examination, RW1 Pratibha Shetty, administrator has not at all uttered any single word that Suraj was riding vehicle bearing so and so, 4754. No such evidence is stated by her in examination chief. And next, para number 17, page 19. The relationship of the deceased as well as the claimants is also in question, my lord. Then I will take my lords to the remaining documents. And 3250, which he was said to have been a conductor in a private bus, is also not questioned. I am not making any submissions on that issue. Para 19, page 17, my lord. Para 17, page 19. Which hospital the deceased as per?
First of all,
Yes.
what is the case of the insurance company? Forget about the evidence.
Please come to Exhibit P1, FIR.
Exhibit P1. You filed your arguments, you filed your objections. What is your case? Are you denying the fact that he is a rider of the motorcycle, but not the pillion rider?
No, he was riding vehicle number. What is my lord? Come.
Your case, please come to your objections.
Yes,
Let's
please.
see your objections. What is your case?
In paragraph number 2 of the written statement, my lords.
And where are the, this here is there?
It is. They have clearly admitted, this here. They have clearly admitted the involvement of the vehicle, the very same. They have not disputed it. And also they have admitted that the deceased was moving as a pillion rider. Para 2 of the written statement. Shall I read, my lords?
No, para 5 of page number 3. What is the defense?
Written statement.
No, I'm looking at your written statement.
Please.
Paragraph 2. my lords. This respondent states that the rider of motorcycle bearing registration number KA 19S7088, namely Praveen and pillion rider deceased Suraj Rao, have consumed alcohol in the New Year party at midnight, and thereafter both of them have ridden the said motorcycle in a zigzag manner in the road in a drunken mood, and due to which they caused the accident, and pillion rider Suraj has died in the said accident. Hence, this respondent is not liable to pay any compensation to the petitioner. Hence, they have clearly admitted the involvement of the vehicle, and also they have stated that the Suraj was the deceased was the pillion rider. Their contention is they were under the influence of alcohol, but there is no cogent.
Precisely the reason why the court had not considered their case, because you cannot, contrary to your own pleadings, you can't adduce any evidence or examine, put forth the questions to the witness basing on some document. That's the whole basis for the court. So your appeal is also there.
Please, madam, for enhancement, that there is a.
Where is your appeal? Let's look at the compensation. Where is it?
Our contention is that, my lords, he was earning.
It's a case of death.
Death, my lords.
Oh, what
The
is
other is the
age?
claimant. He was aged 20 years, sir. My lords, asked 20 years, my lords, 20 years.
Occupation,
Occupation, he was working as a conductor in a private bus, sir.
conductor,
How?
salary,
Salary, we have contended that he was earning 3,250 rupees per month. 3,000 has been taken by the tribunal.
huh?
3,250 rupees per month, my lords.
We'll take 3,250.
Please, my lords.
Hmm.
And multiplier, my lords, since he was aged 20 years, as per schedule 2, since it is a 163A petition.
No, first
17
of all, future prospects at 40%.
No, my lords, 163A petition this is.
163.
Please, my lords, as per schedule, we have to go.
Hmm.
Schedule, my lords, as per, for 20 years, my lords, multiplier is 17.
Hmm.
And,
One minute.
please, my lords, 1/3 has to be deducted.
No, 1 minute.
Please.
So 3,250
Into 12.
What is this calculation? Come to page 21.
Let's
Page 21 of the order.
calculation, my lords.
Calculation of the tribunal.
Tribunal, 3,000 has been taken, 1/3 has been deducted towards the personal expenses. So 2,000 rupees per month into 12 for 12 months. 16 multiplier has been taken. That has to be 17 has to be taken.
No, if you take 3,220,
250.
it would be how much?
Well, 3,250 into 12.
Hmm.
Into 16 is the multiplier. And if you take 2/3, my lords, that is a deduction of 1/3. It will come down to 4,16,000.
No. 3,000.
1 minute, my lord. I will 3,250
into what is the multiplier?
My lords, it will come down to 39,000.
No, 3,000.
250 into 12. So it will come down to 39,000.
Divided by 1/3.
Divided by 3. 1/3 has to be deducted. 13,000 has to be deducted.
13,000 into?
And it will come to 26,000 will remain, my lords. 26,000 into 16 into.
No.
1/3
is 13,000.
1/3 has been deducted, my lords.
That is 13,000.
Then 26,000 will remain. 26,000 into 17 is the multiplier.
No.
3,250 into 12 is 39,000.
39,000.
For 1 year.
1 year.
1 year. If we deduct 1/3, that is 13,000. If we deduct 1/3, that is 13,000. Remaining is 26,000 will remain. 26,000 into
26,000.
Multiplier is 17.
Into?
17 multiplier. That will come down to 4,42,000 dollars.
4,42,000. What are the on the conventional heads as per the table? What are the
schedule,
amounts?
my lords?
5,000.
5,000 rupees.
No, on all counts.
Yes.
That is under 160. That is the only.
Loss of estate, funeral, everything is 5,000.
Everything is 5,000. 4,500 rupees total.
Here, what is granted is loss of estate 2,500. Funeral 2,000 is granted.
4,500. That is correct. 4,500 only.
Total how much?
4,500.
That's what has
That's
been
what
taken.
is granted.
Correct. My lords. 4,46,500 total.
Expenses 2,000. 4,500 plus. It comes to 4,46,500.
500. Please.
What is the interest?
6%.
6%.
No, granted.
6%.
Granted is also 6%.
6%.
Before making a decision, my lord, I wanted to make submissions, further submissions to the court. Examination of PW doctor. Kindly come to the chief examination and cross of PW2 doctor. That is the doctor whom they have examined as PW2. Deepak Rai.
Deepak Rai doctor ಅಲ್ಲ, is an eyewitness.
Eyewitness ಇರಲಿ. Deepak Rai is the PW2 whom they have examined. Kindly come to cross examination.
Read.
Shall I read in Kannada that ನಾನು BA ಪದವೀಧರನಾಗಿದ್ದೇನೆ. ನಾನು 2005ರಲ್ಲಿ ಮಂಗಳೂರಿನ ಕೆನರಾ ಕಾಲೇಜಿನಲ್ಲಿ BA ಮುಗಿಸಿರುತ್ತೇನೆ. ಅಪಘಾತ ನಡೆದ ಸಮಯದಲ್ಲಿ ನಾನು ICICI ಲೊಂಬಾರ್ಡ್ ಜನರಲ್ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿಯಲ್ಲಿ ಸೇಲ್ಸ್ ಆಫೀಸರ್ ಆಗಿ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದೆ. ನಾನು ಈ ಕೇಸಿನ ಅಪಘಾತದ ಬಗ್ಗೆ ಸಾಕ್ಷಿ ಕೊಟ್ಟಿರುತ್ತೇನೆ. ನಾನು JMFC ನ್ಯಾಯಾಲಯದ ಕೊಟ್ಟ ಸಾಕ್ಷ್ಯದ ದೃಢೀಕೃತ ನಕಲನ್ನು ನೋಡುತ್ತಿದ್ದು ಅದನ್ನು R1 ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ನಾನು ನಿಶಾನ R1 ಎಂದು ಹೇಳಿದಂತೆ ಹೇಳಿಕೆ ಕೊಟ್ಟಿಲ್ಲ.
With regard to the evidence given before
ನಿಶಾನೆ
criminal
R1
court,
ರಲ್ಲಿ
is again
ನಾನು
saying the very
ಹೇಳಿದ್ದು
same.
ಸುಳ್ಳು, my lord. Exhibit R1 which we have produced after examining the officer of the company.
Court has already discussed it and given a finding on that.
Please,
So
no,
what are
further.
the contents of exhibit R1?
No.
Or that deposition that I have seen already?
No, my lord. At this next para, my lord.
Yes.
ನಾನು ಹೋಗುತ್ತಿದ್ದ ಮೋಟಾರ್ ಸೈಕಲ್ ಹರ್ಷಾರ್ ಅವ್ರಿಗೆ ಸೇರಿದ್ದು. KA 194754 ಮೋಟಾರ್ ಸೈಕಲ್ ಯಾರಿಗೆ ಸೇರಿದ್ದು ಅಂತ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಮೃತ ಸೂರಜ್ ಇರೋರು ಮೋಟಾರ್ ಸೈಕಲ್ ನಂಬರ್ KA 19R4754 ಅಪಘಾತ ದಿನಾಂಕ ದಿವಸ ಚಲಾಯಿಸಿಕೊಂಡು ಹೋಗಿ ಕಂಬಕ್ಕೆ ಡಿಕ್ಕಿ ಹೊಡೆದ್ರು, ಪೆಟ್ಟು ಮಾಡಿಕೊಂಡು ಈ ಅಪಘಾತ ಮೃತ ಅಂತ ಹೇಳಲು ಸರಿಯಲ್ಲ. Once he said that the same motorcycle Suraj was riding, he has hit the electric pole and died. Kindly come to
They
FIR.
have put a
Exhibit
suggestion.
P1 and R6.
It is not like that. They have put a suggestion that
No,
whether
exhibit
KA
P1
19
as
or
well as R6
4754.
may kindly be looked into mallet. What Deepak Rai has said.
Court has not relied the complaint or the FIR which is filed by you because neither it is a signed or a certified copy by the competent.
True. More than that, my lord.
Why should this court look into it?
No.
And why that finding is wrong?
That is wrong, my lord. Which hospital the person who was died in the accident was taken? Which is the doctor? Whether they have examined any doctor? Wait, where is the MLC? Where is the IMV? Where is the seizure of vehicles? Is it not a fraud on the part of the court, my lord? Justice should prevail, my lord.
Why your insurance company is very casually filing the written statements?
No, have examined officer, we have taken it for further.
You cannot admit, you cannot examine a witness contrary to your own pleadings. You will examine the witness to elicit what you wanted from that. What is your case? What are your pleadings? Court also will not go beyond the pleadings. When you yourself are admitting accident had taken place and because they have consumed alcohol and for that reason the accident has happened, and how are you permitted without even amending the pleadings, without even amending the pleadings, any amount of evidence that is let in?
Then that may be a fault on my part, my lord. I don't deny that. There may be a little lapse on my part. But the court should look into why there are two FIRs on the same day by the same complaint on two motorcycles.
The thing is, admitted facts need not be proved.
No, my lord, before going to that, kindly come to the FIR R6 which I have produced. The same complaint was lodged by Deepak Rai.
I will also, Mr. Venkatesh shall give all the findings
Please.
on all your contentions.
Please, my lord.
Yes. Please come. Agreed with orders passed in MVC number 327 of 2006 dated 31st August 2012. Both the claimant as well as the insurance company are before this court. The claimant's appeal is 720, the insurance company's appeal is 724 of 2013. And the claimant's appeal is seeking enhancement is MFA 4973 of 2013. It's a case of the claimant that on 1/1/2006 at about 2 a.m. when the deceased Suraj was proceeding as a pillion rider from Patavinan Gade to was proceeding as a pillion rider in a motorcycle. The said motorcycle was ridden by the respondent number 1 in a rash and negligent manner. And when the motorcycle reached the place, because of the zigzag manner in which the vehicle was ridden, he lost control and fell into the ditch. And due to this, deceased sustained injuries and fell unconscious. He was taken to the hospital and declared dead. The claimant is the brother of the deceased. The second respondent, insurance company, had filed its objections. They stated that the rider Praveen and pillion rider deceased Suraj have consumed alcohol in the New Year party at midnight, and thereafter both of them have driven the said motorcycle in a zigzag manner in the road in a drunken mood, and due to which they caused the accident, and pillion rider Suraj died in the accident. Hence, the respondent number 2 is not liable to pay the compensation as the accident has happened because of the contributory negligence on the part of the deceased. They have denied that the claimant is the legal heir of the deceased. And it is also further their case that the insurance policy in respect of KA 19/67088 is not covered the risk of pillion rider in the motorcycle since no additional premium is collected. Hence, the respondent number 2 is not liable. Before the tribunal, the claimant has examined himself as PW1 and also examined PW2 to 3, 2 and 3. On behalf of the respondents, RW1 and 2 were examined, and exhibit P1 to P16 are marked on behalf of the claimant, and on behalf of the respondents, exhibit R1 to R8 or file or marked. Exhibit P2 is a complaint, and exhibit R6 is the FIR.
Exhibit P1 is the FIR.
Exhibit P1 is FIR, and exhibit R6
is the FIR relying by
Also
them.
FIR, my lord. Both are FIR.
Charge sheet is at P12.
Exhibit R6 is FIR, which is relied on by the insurance company. According to them, there are 2 FIRs. Then they have relied on the deposition in CC number 2344 of 2006, wherein the complainant had given according to them, for the purpose that the complainant has given a contradictory version in CC number 2355 of 44 of 2006. They have relied on the said deposition. The trial court had held that the accident had taken place because of the rash and negligent driving of the rider of the bike, and held that the insurance company is liable to pay the compensation. While considering the contention of the insurance company with regard to that there are 2 FIRs, and the claimant, the deceased is not a pillion rider, but he is a rider of the vehicle, the court gave a finding that in the written statement, they have already taken a stand that the accident had taken place, but it is the accident took place because of as the rider and the pillion rider have consumed alcohol and contributed to the incident. When it comes to the deposition, the court gave a finding that the deposition of a witness in a criminal case cannot be looked into before the court. Further, a party cannot be permitted to adduce evidence in respect of contention which they have not taken and in respect of which they have not given any evidence in their examination in chief. Simply producing documents without taking any contention or not stating in examination in chief will not help the respondent in any way. Further, court also gives a finding that as far as the FIR which is relied on by the insurance company is concerned, it is stated that the court has observed that
Page number 12 of the judgment, top one.
Page?
Page number 12 of the judgment, internal page 12.
That petitioner has produced exhibit P1, that the Xerox true copy signed and dated, and it is Xerox certified copy of the original FIR. Exhibit R6 is not at all dated as true copies, though it is stated to have been signed and sealed by SHO Kavur PS. The said document itself contains contradictions and inconsistencies. Because in column number 7, it shows the details of known suspected, unknown accused with full particulars, rider of the KA 19S7088 motorcycle rider Suraj. But it shows in column number 12 that the said Suraj was riding the vehicle bearing the registration number KA 19/R4754. Hence, the court had disbelieved the said evidence or failed to had not considered exhibit R1. Then coming to the evidence, it is observed by the court that in the subsequent cross-examination of the prosecution at para 3, the complainant has admitted that himself and Harsha and Praveen took Suraj and all admitted deceased to hospital, and he has also came to know that deceased succumbed to the injuries at hospital. But he stated that he cannot say whether the accident occurred due to the negligence of the accused. Even he has admitted his signature on exhibit P2 Mahajar. The witness has admitted before the court regarding taking the deceased and his signature on exhibit P2. The court observes that he is an educated person. Before the criminal court, he has not supported the prosecution. But it is evident before the court that complaint bears his signatures. He himself has taken the deceased to the hospital along with others. So unless he was present at the spot of the accident, he cannot take deceased to the hospital. The court observes that simply because that witness has not supported the prosecution regarding giving evidence against the accused in criminal case, that does not mean that his evidence before the tribunal cannot be believed, and accordingly not considered the said content as a contention of the insurance company, and accordingly held that this is an application filed under 163 of the Motor Vehicles Act, and the insurance company, as the said vehicle is insured, the insurance company is liable to pay the compensation. When it comes to the compensation, is a case of the claimant that is earning 3,250 by working as the conductor in a private bus. The court had taken the income at 3,000 3,000 and granted a compensation of an amount of rupees 3,88,500 towards loss of dependency, loss of estate 2,500, funeral rituals and conveyance 2,000. Total an amount of rupees 3,88,500 is granted. Next paragraph. Land counsel appearing for the insurance company submits that the fraud is played by the claimants on the court. It is submitted that the exhibit R1 placed before the court clearly reveals that there are two vehicles and he is a pillion rider. The involvement of the vehicle itself in the accident is doubtful. It is submitted that the court has failed to consider exhibit R1. It is that he submits that no MLC register is placed before the extract of the MLC register is not placed before the court. No IMV report is placed. They have failed to prove the accident in that accident, and all these aspects, and also the deposition of the complainant before the criminal court clearly shows that he has taken account. He has not cooperated with the prosecution, and he had denied the several contentions, and his presence, including his presence, it is submitted that in view of the same, when the accident itself is not proved, and the involvement of vehicle insured itself is in dispute and doubt, the claimant is not entitled for compensation. Next parallel, counsel appearing for the respondent, the appellant claimant submits that the court had rightly discarded the evidence of, had rightly not considered the evidence in the criminal case given by the complainant of the FIR. He is a complainant.
Complainant is one
Deepak, right?
PW.
The complainant.
Deepak.
He is the complainant.
Yes, my lord. Deepak, right?
Is the complainant, and also court had rightly disbelieved the case of the insurance company as they themselves have admitted the accident, and now it is not permissible for them to take a contra view. When it comes to the compensation, he submits that when an amount of rupees 3,250, when it is this case that an amount of rupees 3,250 is earning, and this accident is of which year?
2006 months.
2006. The court had taken it as 3,000, which is on the lower side, and on that count, the compensation needs to be enhanced. Next, having heard the counsels on either side, there is a material on record. First, coming to the aspect of liability, the insurance company states that the accident, the vehicle is not involved in the accident. A fraud is played on the court, and the vehicle, there are in exhibit R1, the number of two vehicles are given, and IMB report is not placed, and a report is not placed before the court. MLC extract is not placed. All these things creates any amount of doubt on the accident that had taken place. They had taken place, and these aspects were not considered. When the respondent insurance company had filed its written statement before the court, they have categorically admitted the accident, but it's their case that both of them have consumed alcohol, rider and the pillion rider, and they have contributed to the accident. Further, they were not having a valid driving license. By filing such a written statement, they themselves are admitting the accident. And once that is their pleading, the parties cannot be permitted to adduce evidence contrary to the pleadings, and any amount of evidence contrary to the pleadings cannot be considered by the court. Even they have not filed any additional written statement taking such a plea. The court on this aspect has rightly dealt with and rightly discarded, rightly not considered their evidence, their case, and Exhibit R1 as observed by this court in the preceding paragraphs, the observation of the court on Exhibit R1 and the evidence of the complainant in the criminal case. Also, the court had considered and rightly held that cannot be a basis to disentitle the claimant in view of in the considered opinion of the court. All the findings by the tribunal on the aspect of Exhibit R1, the evidence in the criminal case do not call for any interference from this court. And this court is of the view that there are no grounds in the appeal filed by the insurance company, and accordingly, appeal of the insurance company is dismissed. Then coming to the enhancement of the compensation, as this is an accident of the year 2008, 2006, and the amount of 3,250 as stated by the amount that is earning, that the deceased is earning, the court ought to have taken 3,250. Instead of that, the court had taken 300, and this court is inclined to take 3,250. And after deducting 1/3, and the multiplier is
17 will come for 20
and
years.
applying the multiplier 17, the loss of dependency would come to 4,42,000. Towards loss of estate, funeral expenses, 2,500, 2,000 the court had rightly granted, and there are no grounds to interfere. Altogether, the claimant is entitled for an amount of rupees 4,46,500. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 3,88,500 to 4,46,500. The amount in deposit shall be forthwith transferred to the trial court.
Actually.
Yes. Yes.
Preparing for the appellant, my lords. The claim petition is dismissed, my lords.
On what ground?
Grounds it at, my lords, at page number 6 of the judgment, my lords. Wherein, my lords, after the accident, immediately he was admitted to one Mahesh Hospital, my lords, wherein he has stated that in wound certificate, Exhibit P3, my lords, it is stated that fall from bike. So the trial court has come to findings that, my lords, he himself was riding the bike and due to skid, he has fallen and he has filed a claim petition. On that ground, it was dismissed, my lords. The grounds is, my lords, I was riding as a pillion rider. On the same day, my lords, when I was admitted to KMC hospital.
Date of accident?
Date of accident, my lords, 22/1/2013, my lords.
Complaint?
Complaint, my lords, complaint was filed, my lords.
26/4/2013.
Please, my lords. The reason for delay is, my lords.
MLC?
MLC, my lords. Yes, my lords. Intimation was given on the same day, my lords. But the police has not taken any action against them.
Where do you get that?
At page number 167, my lords, in trial court records.
No.
In findings, it is not stated anywhere.
No. Exhibit.
My lords, in records, it is there, my lords.
No, not the records, sir. It must be marked.
No, my lords, it is marked along with the case sheet, my lords. Exhibit P11. The MLC report, my lords, 160. 167. It is stated that road traffic accident, my lords. In my deposition also, my lords, I have stated that before the police, I have stated.
No, if the pillion rider, just because it is stated that fall from the bike.
My lord, it is not the case. Accident took place on 26/1/2013. No complaint was filed. Later on, he files a private complaint, which I had pointed out yesterday. He files a private complaint, go before the magistrate, or the direction of the magistrate, a complaint came to be registered in April 2013, on 26th April 2013. Thereafter, police have investigated the, after registering the complaint.
Before that.
No, police.
No, on the same day, the hospital authorities have sent the intimation to the police.
Yes.
So why should we not believe that?
It is the finding
In
of
those
the.
circumstances, delay in giving the complaint.
No, I'm not on that point. Police have filed a B report. They've investigated this complaint. They say that there are no eyewitness, there are no material to show that he was proceeding on a pillion rider on that particular day, being rode by one so and so. He says one, as per the complaint also. No, they have not examined. No, he says on that particular day, he was riding as a pillion.
B report is exhibit?
B report is
R1,
filed R1. And it is in Kannada, wherein which police have clearly stated that there is no witness, no material to show that the claimant was proceeding as a pillion rider and one so and so was riding the motorcycle. So in view of no documents and even except claimant, nobody else is saying that he was proceeding on a motorcycle and he met with an accident. So that's the reason they have filed a B report. And that B report was very much produced before the tribunal. And they have not examined, even to say that, assuming for a while, he was proceeding as a pillion rider, nothing prevented him to bring the rider and examine him before the court. And there is, except him, even except the hospital record says that there is a possibility that he might be riding himself and might have had a self fall. That's the reason he could not procure any witness. Even police at the time of investigation, even they could not find anybody else who can say that the accident has taken place.
They must have examined the rider of the vehicle.
Yes, they have not done it.
No, not he. Police might have examined the rider of the vehicle.
Who says that he was not riding? That is what the B report says.
No, my lords.
And the B report in detail.
The B report.
In B report, my lords, statement of accused, he has stated that he was riding the two-wheeler and the claimant was pillion rider. Even, my lords, in the B report, second page, second para from the bottom, my lords, the doctor who has treated both of them, where Mahesh Hospital, the first hospital, my lords, he has stated that on the day one Harsha J, who is the claimant here, has admitted and sustained grievous injuries. And another person, M. Ramesh, who is the accused, who is the rider, he has also admitted, not admitted, he has treated as an outpatient.
How the accident has happened?
My lords, accused was riding the vehicle. I was a pillion rider. He drew the motorcycle in a rash and negligent manner, and it has fallen, my lords. He had applied suddenly brake and he has fallen, my lords. Because of that, I have sustained grievous injuries.
What do you say? Is it so? In the B report, it says
No, in the B report, it says that at the last paragraph of the B report, it says that except the claimant who says that on that particular day.
My lords. Read para number, second para.
No, before that, I would come to the
where, my lords, the doctor who has treated the
that is understand
claimant.
Why is that para number 2?
No, doctor says there is one person who got injured.
What is that para you're referring?
Para second from bottom.
Please read that.
Second page. Yes. On the day, claimant has admitted.
Better read.
Please, ma'am.
It just says, my lord, this paragraph says that on that particular day, because of the injury sustained in the accident, he was admitted in the hospital and there is a wound certificate issued by so-and-so hospital. That's all it says. It doesn't testify or says that there is an accident took place where he was.
He says the rider of the bike has stated that he was riding.
No.
My lords, it is there. Doctor has stated that both of them have admitted. Claimant has sustained grievous injuries. Another person, M. Ramesh, who is the accused, he has sustained normal injuries, simple injuries, my lords. It itself shows that, my lords, both of them were riding together.
Yes.
Though he has been not admitted.
It says that, my lords, I would read it out in Kannada and I would translate it. ನಂತರ ಬ್ರಹ್ಮಾವರ ಮಹೇಶ್ ಆಸ್ಪತ್ರೆಯಿಂದ ಗಾಯಾಳು ಹರೀಶ್ ಮತ್ತು ಆರೋಪಿತ ಎಂ ರಮೇಶ್ ಅವರುಗಳು ಗಾಯದ ಪ್ರಮಾಣ ಪತ್ರ ಬಂದುದನ್ನು ಸ್ವೀಕರಿಸಿದ್ದೆನು. ಡಾಕ್ಟರ್ ರಮೇಶ್ ರವರು ಗಾದ ಗಾಯ ತೀವ್ರವಾಗಿದ್ದು ರಮೇಶ್ನಿಗೆ ಆದ ಸಾದಾ ಗಾಯವಾಗಿದ್ದು ಎಂದು ಅಭಿಪ್ರಾಯಪಟ್ಟಿರುತ್ತಾರೆ. ಉಡುಪಿ RTO ಕಚೇರಿಯಿಂದ so which means that we have received 2 wound certificate of one Harish and one accused Ramesh as per the say of Harish, that is a claimant. And Harish had sustained grievous injuries, and Ramesh, as Ramesh did not sustain any grievous injuries, he never got admitted in the hospital and not treated at the hospital. Later on, we have given a requisition for conducting an IMV, and IMV inspector has conducted the inspection and says that accident did not occur on account of the mechanical defect. And later, next paragraph is relevant, which my learned friend is not going through. Next paragraph, it says that except the claimant, there is no other person who is testifying his statement saying that on that particular day, one Ramesh.
Doctor is saying.
No, doctor did not say. They say that they have received 2 wound certificates from the hospital pertaining to one Ramesh and one Harish. It is the doctor did not say. They have not recorded the statement of. It is not the statement of the doctor. It says that from the hospital.
We cannot rely on that B report where they have not stated anything about.
But even otherwise, my lords.
Have they examined the rider of the vehicle? What is his evidence?
No, next paragraph is relevant. I would read that, my lords. It says that, I would read it and translate. ಪ್ರಕರಣದಲ್ಲಿ ಫಿರ್ಯಾದಿದಾರರು ನೀಡಿದ ದೂರಿನ ಆರೋಪಿ ಎಂ ರಮೇಶ್ ಮೋಟಾರ್ ಸೈಕಲ್ ಅನ್ನು ವೇಗವಾಗಿ ಚಲಾಯಿಸಿ ಅಪಘಾತ ಮಾಡಿ ತನಗೆ ತೀವ್ರತರದ ಗಾಯ ಉಂಟಾಗಿರುತ್ತದೆ ಎಂಬುದಾಗಿ ದೂರಿರುತ್ತಾರೆ. ಫಿರ್ಯಾದಿದಾರರು ಮಾತ್ರ ಅಪಘಾತವಾಗುವಾಗ ಎಂ ರಮೇಶ್ ಅವರು ವಾಹನವನ್ನು ಚಲಾಯಿಸುತ್ತಿದ್ದರು ಎಂದು ಹೇಳುತ್ತಾರೆ. ಅವರ ಹೊರತಾಗಿ ಬೇರೆ ಯಾರೂ ಪ್ರತ್ಯಕ್ಷ ಸಾಕ್ಷಿ ಇರುವುದಿಲ್ಲ. ಇಟ್ ಸೇಸ್ ದಟ್ the claimant in specific terms says that one Ramesh was riding the motorcycle due to his negligent act that he had met with an accident and sustained injuries. Except the complainant or the claimant herein, there are no other witness or no other person who testifies his statement saying that.
Further, what they have to do, they have to examine.
Further, my lord. ವಾಹನದ ಮೂಲಕ ಉಮೇಶ್ ಶೆಟ್ಟಿ ಅವರು ತನ್ನ ಹೇಳಿಕೆಯಲ್ಲಿ ತಾನು ಹರ್ಷ ಜಿ ರಾವ್ ಅವರ ಮನೆಯಲ್ಲಿ ಮೋಟಾರು ಸೈಕಲ್ ಇಟ್ಟು ಹೋಗುತ್ತಿದ್ದು ಒಮ್ಮೊಮ್ಮೆ ಹರ್ಷ ಜಿ ರಾವ್ ಮೋಟಾರ್ ಸೈಕಲ್ ತೆಗೆದುಕೊಂಡು.
Have you questioned the B report?
The B report was
kindly he may be directed to file the translated copy. I think that would show much light on the.
Have you questioned that?
B report has been challenged, my lords, but at what condition it is in that, my lords, it is, I do not know. It is challenged, my lords.
Which year is that? Come on. Come. Take. The present petition, the present appeal is filed. Agreed with the order passed in MVC number 5, agreed with the dismissal of MVC number 572 of 2013 dated 8 July 2016, whereby the claim petition filed by the claimant is dismissed. It is the case of the claimant that he is a pillion rider and the rider of the bike rode the bike in a rash and negligent manner on 22/1/2013 at 7:06 p.m. And due to the rash and negligent driving of the rider, he fell down and sustained injuries. He took treatment as inpatient from 22/1/2013 to 28/1/2013. And further from 18/2/2013.
And before my lords, one more thing. There is one more statement in the B report which says that the vehicle belongs to some other person, and at the time of the accident, it's a claimant who was riding the bike. As he did not possess the driving license, he is time and again making an allegation saying that the vehicle was rode by one Ramesh, not by him. And that is also one of the aspect that is forthcoming from the B report.
2013 up to 22/2013. The claim petition is dismissed on the ground that when the accident had taken place on 22/1/2013, the complaint is given on 26/4/2013. The police, when they filed a private complaint and when the same is referred to the police have conducted the investigation and thereafter filed a B report. They stated that except the claimant, there is no other evidence. There is no other evidence to show that they met with an accident and sustained the injuries.
ಕೋರ್ಟ್ ಆಯ್ತಲ್ಲ ಸರ್?
Any of the counsels on either side, there is a material on record. According to him, an accident has taken place, though as per the hospital authorities have given an intimation, the crime was not registered. Later, he had filed a complaint and private complaint, and the same was referred to the police, and the police, after investigation, has filed a B report. If the said B report is filed, whether it is questioned on a query from the court, whether the same was questioned, can counsel submits that they have questioned, but he is not aware of what has happened to the said proceedings.
To that extent, my lords, to that extent, I can produce, my lords, the details.
He is not aware of what has happened. Some time is granted, he will produce the same. Next para. This court has perused the order passed by the trial court. When he has not, when according to him, someone is riding the vehicle and both of them have sustained simple and grievous injuries. In that case, the first thing you should have done is you should have examined the concerned person and the rider of the motorbike. He has not examined the rider of the bike, and in this case, the delay in giving the complaint, this court is not going to that aspect, as per the case sheet, the intimation is given on the very same day to the police, but however it contains that it's a fall from the bike. Whether it is on the burden of proof in this case is preponderance of probability. Even on preponderance of probability also, the petitioner, the appellant claimant could not satisfy the court and discharge the burden cast upon him, then an application is filed under section 166 of the Motor Vehicles Act. In that view of the matter, this court do not find any reasons to interfere. Accordingly dismissed.
Much obliged.
Next para. Next. What is this permission to amend the appeal? Where is Mr. Chetan?
To amend the appeal, my lordship. In the time of filing, my lordship, the appellant has not taken grounds for challenging the liability fixed on
TCR is required in this.
Please.
Registry is directed to call for the TCR. This matter after the TCR is received. Yes, next. Admit post for final hearing. Call for the TCR is already there. Admit post for final hearing TCR.
Records, ma'am.
It's called for the TCR. Yes. Thank you for the excellent. Where is Pradeep? You are ready?
Yes. This was heard by your lordship on Saturday, my lord. It is a case of injuries, my lord. Nature of injuries are concerned, your lordship may kindly see.
You're seeking enhancement?
Yes, I'm seeking for enhancement of.
How much is the amount claimed?
Claim was 9 lakhs. 3,24,000 has been awarded. Nature of injuries, your lordship may kindly see. First one is fracture of shaft of humerus left. The other injuries are, my lord, that is loss of 5 teeth and Elias class 3rd fracture in relation to
loss of toes.
Pardon me.
Toes.
5 teeth.
Teeth.
And also the other fractures of the teeth is concerned. Elias class 3rd fracture in relation to upper left and right central incisors.
No, that we will go later. What is the disability according
disability
to?
As per the doctor, so far as orthopedic surgery is concerned, 35.4 in respect of upper limb and 12 so far as whole body is concerned. And tribunal has taken 10. But that senior dental surgeon from government hospital, he has stated a 12% disability so far as this teeth and other things are concerned.
No.
That has not been taken
If
into.
he lost the teeth, where is the disability?
But
The permanent teeth
he
can
cannot
be-
chew the hard food, he cannot take the.
No,
there
no,
are
permanent teeth can be, there can be.
artificial
implants.
denture also, he has to undergo surgery for artificial denture, that has to be
For
replaced.
For that you will get the compensation.
Yes.
But where is the disability for that?
But doctor says that disability is concerned for orofacial disability, 12%, that is the evidence of doctor, PW3.
What did the court do?
Court has not taken into consideration that aspect.
Please come to.
Only 10% disability has been taken. But even orthopedic surgeon says 12% to the whole body.
They're taken 10%.
Yes.
What is your income according to you?
Income 4,450 per day as a tailor. Per day, but tribunal has taken
Per month how much?
7,500 tribunal.
No, per month how much then?
Per month that he has not stated.
Comes to
He is a
12,000.
tailor,
12,000.
4,450.
12,000.
12,000.
No,
2011.
4,450 she say.
400
Per day. I'm sorry. 450, 400 to 450. 2011 extent. 7,500.
Court had taken how much?
7,500.
Which year is this?
2011. But it is a skilled job, my lord. Even charge sheet also it is shows that he was doing.
Court had taken more.
Yes.
So we don't have to interfere on that.
Income.
Then please come to the pain and suffering.
40,000 has been awarded.
Yes, what do you say?
Because see grievous injuries, my lord, loss of faith also there.
Pain and suffering may be increased by another 25,000 rupees.
70,000.
Last time your lordship said that 80,000. So far as that is AD is concerned on Saturday when I argued this matter.
Loss of income. I don't remember.
Laid up period 25,000. That is also on lower side. Incidental
Loss of income
25,000.
during the laid up period.
Yes.
Now we are considering 7,500 for 4 months.
30,000.
Then how many days he was in hospital?
6 days. He has undergone one surgery. And so far as dental problem is concerned, he has taken treatment through OPD. Doctor evidence is there.
Reasonably granted 25.
25,000.
Medical expenses 10,000. Only 3,000, 26,000 is the bill. Bill is 3,000 to 206. That's all. But 10,000 has been awarded. Medical expenses. Government hospital, Bowring Hospital, he has undergone treatment.
So no dispute on that.
Loss of future income 10% was taken. 7,000.
That we will see now.
Yes.
We'll take 12%.
Please, Miller.
12% we will take.
Yes.
Multiplier is
What
16.
is the multiplier?
16, my.
16.
And
Comes to
future, he has to undergo the doctor evidence is PW2 evidence.
We'll just complete. We'll
Yes,
complete one
Okay.
step. I have to do the calculation.
Yes, ma'am.
1,72,800. Then here loss of amenities and discomfort.
The loss of amenities 40,000 is granted.
No, because
Apart from that, 40,000 is granted on the head of disability.
for the
Even facial
the-
disfiguration is there.
there is a
for the
permanent
incisors.
physical impairment. And that is compensated there.
Yes, yes. Facial disfiguration is there, my
No,
lord.
that's
because-
what. That's where it comes.
Yes.
We'll come. We'll
And
continue
permanent physical impairment 40,000 has been awarded.
this. Then what do you say about future medical expenses?
The future medical
So he
expenses,
lost.
nothing
He
is
lost the
granted.
teeth. He has to.
Another 25,000. Miller.
Even orthopedic surgeon also says that he has to undergo surgery for removal of implants.
Both the counts 40 we will for facial and ortho. It comes to 4,37,800 against the amount of
3,24,000.
3,24,000. And this may kindly be included, my lord. Permanent physical impairment, 40,000 may kindly be included. In the, that is one head awarded by the tribunal.
That is all about,
Yes.
that is all as it is taken.
Yes, ma'am. And 8% interest has been awarded. They have not challenged. This,
But still on enhanced amount, we made
Enhancement
it
6%.
6%.
yes, yes.
Please come. Agreed with award passed in embassy number 117 of 2012, dated 26 March 2015. The claimant is before this court. It is stated that in the accident that took place on
10/12/2011
at about 4:30 p.m., the claimant had sustained injuries as per the wound certificate.
Exhibit P4. Exhibit P4.
No. Where is that?
Injuries on para 36, your lordship may kindly see. Para 36 and also
Fracture of left humerus.
fracture of shaft of humerus left side.
Para number?
Para 36.
The
And,
petitioner has suffered fracture shaft of humerus left side, injuries on the right side of the face, injuries on the infra-orbital area, injuries on the chin, injuries over lower lip, injury on the left leg at 2 different places, injuries over right maxillary area, loss of 5 teeth and loosening of several teeth from sockets, fracture of several teeth, fracture of upper anterior segment of maxillary, crush injuries on the left side. As per the orthopedic doctor, the disability to the limb is 35.4 and to the whole body it is 12%. As per the dentist, the disability is
12%.
is
Over
PW3.
12%.
12%.
Orofacial region, that is
12%. According to the claimant, she is earning an amount of rupees 4,500 per month, and the court had taken 7,500, 4,500, 450 per day, and court had taken 7,500, and the disability was taken, considered at 10%, and granted that the compensation as per the table given below. Extract the table at page number 25. An amount of rupees 3,24,000 was awarded as compensation. Next para. Learned counsel appearing for the claimant submits that when the claimant had sustained several fractures under the head of pain and suffering, court had granted only 40,000, which is on a lower side. Further, it is stated that the loss of income during the laid-up period was also not reasonably granted. And coming to the loss of future earning, it is submitted that even that as per the doctor, the disability is 12%. Court ought to have taken 12% as a disability to the whole body. And to the loss of amenity and permanent physical impairment, also the amount needs to be enhanced. Further, for the future medical expenses, no amount is granted. It is submitted that the compensation that is awarded is not just and reasonable. Counsel appearing for the respondent insurance company submits that the court had granted reasonable compensation and rightly considered all the aspects, and in fact the compensation that is awarded is on the higher side. No interference is called for. Next for having further counsels on so and so. Considering the multiple fractures, this court is granting an amount of 70,000 under the head of pain and suffering. Coming to the loss of income during the later period for 5 months, this court is granting an amount of rupees 30,000 towards attendant nourishment, conveyance, medical expenses, and loss of amenities, permanent physical impairment, Court had rightly granted the compensation, and this court is not interfering with the same. Coming to the loss of future income, considering the injuries and as per the evidence, court should have taken 12% as a disability. Hence, this court is taking 7,500 as income into 12 into 16 into 12 by 100. The loss of future income comes to 1,72,800. In the light of the law laid down in Maker also, coming to the future medical expenses, both the doctors, orthopedic as well as the dental doctor, have stated about the future medical expenses. Hence, this court is granting an amount of rupees 40,000 under the head of future medical expenses. In the light of the law laid down in Maker also so and so, towards legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 4,37,800. Accordingly, the appeal of the claimant is partly allowed, enhance the compensation from 3,24,000 to 4,37,800. The enhanced amount shall carry 6% interest.
No interest for 742,
Yes,
742 days.
This court by order dated so and so
22/3/25.
condone the delay of 742 days on the and the claimant is not entitled for the delay of for a period of 742 days for interest. Yes, please. Admit post for final hearing.
Connected case.
Yes.
Serial number 29, connected cases.
Yes, yes. Entire 29 admit force for final hearing. Call for the TCR.
Serial number 30. O Mahesh.
All 18 matters admit for final. There is a delay. In all these matters there is delay.
Yes, ma'am. 29.
Let's condone the delay and then push for final hearing. Call this 29.
Serial number 29.
I am the claimants, my lord.
When you will hear this matter, where there is delay, I am looking at it. Then 29.7, IA number 1 of 19 is filed to condone the delay of 344 days. No objections are filed by the respondent. Same delay condoned on condition. Next 29.8, 344 days, same on condition. Then 29.10, 344 on condition. Yeah, admit post for final hearing, call for the DCR. Yes, 30. Admit.
30.
Admit post for final hearing. 31. Admit post for final hearing.
32.
32 also same.
R1 is good, my lord. Appeal is abetted as against R1. I filed applications yesterday. So far as date of death is concerned, it is not possible for me to ascertain.
What is that?
Respondent number 1. The counsel who is appearing for the respondent number 1 reported the death of R1, but he has not given date of death. As per our 22 rule 10A, it is mandatory on his part to give the date of death. No, now he is not appearing. After reporting the death, he is not appearing. His name is.
Where is IA?
IA number.
IA is not listed for the court.
It is there, man. Pattabi, Mr.
Numbered and come.
Mr. Pattabi Ramansi.
This matter day after tomorrow. Let the IA be numbered.
It is numbered.
Let it come back.
Yeah.
Yes, 33.
33.
Admit post for final hearing.
List number 2. For dismissal. Serial number 1.
While appearing for the petitioner, we kindly pass over the senior will be coming.
My lord, today portal number 14ರಲ್ಲಿ RFA 514 and 515 ಲಿಸ್ಟ್ ಆಗಿದ್ದಾವೆ ಮೇಡಮ್.
On in court hall 25, my lord. See, RFA 515 and 514 has been listed in Court All 25.
What happened?
My lord,
Madam,
In last occasion,
I remember that. What
they
happened to that
said that
RFA?
they will withdraw the petition. They have
That's
waited.
what they said. They said today it's coming up for the orders.
Yes, my lord.
Judgment. Was the judgment pronounced?
Not yet, my lord. It is passed over there also.
List these matters tomorrow.
Tomorrow.
All these matters tomorrow. All this 1 point. If not, no, day after tomorrow.
Day after tomorrow.
It's already 4.
See number 2.
List after service of notice.
See number 3. Prasanna Shetty.
No representation for dismissal tomorrow, day after. Post after service of notice 4. 5.
See number 5.
Case. I may be permitted to serve on the trial court advocate, please.
Then counsel for the petitioner is same lower court counsel and shall file a memo to that effect by 8th of April, or else the petition shall stand dismissed against the.
Let the interim order be extended, my lord.
Interim order is extended till then.
Great.
Next.
I paid process today, ma'am. I paid process today.
What happened for the 2 times?
2 times it has come, one time door lock.
Oh, why don't you take notice on the?
I will take counsel who is appearing for the
Let
trial.
counsel for the petitioner is permitted to take court and summons on the counsel. Appearing for the respondent, same memo shall be filed by 8/4.
I want to extend.
Or else the appeal shall stand dismissed. Look at it. Interim order extend. Next,
Till number
post
7.
after service of notice.
8.
8 also same.
7.
7 also await service of notice.
No, my lord, they filed an wakalat for respondent, my lord.
Man, then why are this, they're not even looking at this. Who appears? Or land counsel for the petition is present, no representation for the respondent. The list this matter day after tomorrow.
27.
Yes.
8.
My lord, await service.
Await service of notice.
I am
List
permitted to also, my lord, I am permitted to serve the council, my lord.
Same.
Please.
9.
Lower court.
9, my lord,
By
sir.
8 you have to file.
Memo by 8.
9 serial number.
At to call.
Yeah.
Yes.
My lord, when my person went to serve the summons, the advocate on record and trial court refused to receive the sworn. He said, we are not appearing, you do whatever you want. And it has been recorded accordingly. And he says you can report the matter to the High Court.
The registry is directed to issue notice to the respondent. Interim order earlier granted is extended until further orders.
My lord, the case is posted on 16th at trial court. This transfer can be done. Meanwhile, IA may be disposed for a stay, interim stay.
Stay is not there in this.
No. You said after serving the notice, you will consider.
Oh, this is by the husband. You're seeking transfer from where to where?
From Alur to Asan to Bangalore.
Asan to Bangalore. Distance?
Reason because the petitioner is 70 years and undergoing treatment in 2 hospitals actually because of the health and age related factors. And still it is going on. And I've produced the medical records already. And not able to travel such a long distance to appear.
What is the age of the respondent?
70. As a respondent is 60. He is a male. And petitioner is a female.
Kumaraswamy.
Tirtha Kumaraswamy.
Oh, she's a lady. Oh, the MC is of which year? Yeah, that's a suit or whatever it is. The proceedings of which year?
No, it's still at the trial stage only.
That's the reason why the court had
No.
not granted you the.
My lord,
interim order.
last occasion when the admission going on, your lordship mentioned that let the notice go to the concerned advocate on record at the trial court.
No. Generally, in all these CPs, stay will be granted. In this case, this is a CP of which year?
Yeah.
MC of which year?
No, this is not MC. This is civil petition.
You're seeking transfer of what?
Transfer of civil petition, OS suit of
The suit is of
288,
which year?
2024.
And it's not a matrimonial proceedings. Suits cannot be transferred
No.
It is basing on your,
No,
your-
my lord, under section 24, you have power and the reasons mentioned in that. That you
that
have.
is the case, everybody will have their own reasons.
No, it's not that. It is a real fact. I have produced a medical record of the petitioner wherein continuously undergoing a treatment in two hospitals. The CMI hospital, wherein she
So
has.
why do you have to go on every date of hearing?
No, there is no even power of attorney available because the children are studying in abroad. There is nobody there to represent. And this also I managed to take the summons I sent from my office. That is the reason actually, my lord. This has to be considered because the case filed is a false case. That's
How we can decide it now?
I
Whether it's
want,
a false case or a.
my submission, my lord, is that a stay may be granted and the transfer of the case to the Bangalore.
Ultimately, this has to be this way. This has to go on this ground. We will not transfer the.
Unless at
land
least
council.
my IA may be considered for stay till the transfer is done.
Considering the age of the petitioner and the element and counsel to the petitioner is submitting. This court is granting limited stay of all further proceedings for a period of 3 weeks. The registry shall issue notice to the respondents.
My lord, we make it for 8 weeks. 8 weeks. Because the case is coming up on 16th.
16th of when?
16th of April.
Then we'll see, is this matter no stay?
No.
Does this matter on?
No, my lord.
This is matter on 9th of April.
My lord,
Notice to the-
my submission is stay should be granted.
No, that day we will grant 3
No,
weeks.
my lord, the reason is unnecessarily the petitioner is getting anxiety. Because of that also she is undergoing the treatment continuously. My request is submission is that stay may be granted.
Stay till 17th. Yes.
Much obliged.
Serial number 10. Nirmala
For the
K.
transfer petition, my lordship. So I have filed 2 IAs. I am for the wife.
What is this amendment of prayer?
It is a prayer. Instead of senior civil judge, I have made an additional civil judge. It's
Coming up for the first time.
Like,
IA number 2 of 25.
and
Filed seeking for amendment of the prayer is allowed. Yes.
and another IA number 2 is for stay, my
Where to
lordship.
where?
From Tumkur to Ramnagaram. It is a 540 kilometers up and down. And she has got 3 children, my lordship, minor children. So hence it is very difficult for
Petition is
her
for
to
seeking
travel.
transfer of MC filed with the husband from
From Pavagada, Tumkur to Ramnagara.
so and so to so and so. It is submitted, the distance is 540 kilometers. And this, it's difficult for the wife to travel all the way on each date of hearing, and she has to take care of 3 kids. Considering the same, there shall be stay of all further proceedings. Till the next date of hearing, the petitioner shall hand summons on the counsel for the respondent and shall file a memo to that effect by 23rd of April. If the memo is filed on 23rd, list this matter on 25th, or else stay granted by this court stands vacated.
Much obliged.
Yes, next.
Number 11. Ranjendra Kumar Sunday.
This case, my lord. My lord, this matter, there was a delay of 10 days in filing the, my lord, initially what happened, there was a second appeal was filed instead of regular second appeal also instead of miscellaneous second appeal. Then my lord, court has entertained and orders, notices have been ordered because there was a delay of 10 days, notices has been ordered. Other side also entered appearance. Then my lord was posted for admission, along with an IA. At that time, my lord, this honorable court has pointed out that no, RSA is not, second appeal is not maintainable. Since it's a remand order, it has to be the miscellaneous second appeal, not the regular second appeal. Then I sought a permission to convert into the MSA, my lord, and that has been permitted. Then, my lord, thereafter, this matter was posted before this honorable court on 18/2/2025. Your lordship may kindly peruse the order. On 18/2, this honorable court, after hearing the counsel who has entered appearance, after he filed objections. After hearing the objections, the delay was condoned. On 18/2/20, I'll read the order, my lord. On 18/2/2025, heard Sri so-and-so counsel for the petitioner appellant as well as Sri Srinivasa so-and-so counsel for the, and gone through the contents of the objections filed. As per the contents of the affidavit filed in support of the petition, the delay of 10 days occurred in preferring this appeal as the petitioner could not hand over the relevant documents to the counsel for the petitioner within time. The said reason appears to convincing. Also, the delay is not inordinate. Therefore, this court considered desirable to condone the delay as prayed for. This petition is allowed. Srinivas so-and-so seeks time to file objections to IA2. IA1, my lord, is a stay application. Then, my lord, in spite of this order allowing this delay condonation, this was ordered to be posted after 2 weeks. When it appeared on the last date of hearing, the registry has again showed that there is a delay of 10 days. IA, there is a mistake on the part of the registry, which I shown in the cause list, saying that IA1 for so-and-so is for delay of 10 days. And this honorable court, my lord, I sent my colleague, my lord, on that day. She was here. And my lord, when she has made a submission saying that delay has already been condoned and is by wrongly it has been done, the other friend, my learned friend, my lord, the junior of that Srinivas who has filed in Wakalat, he has opposed and he said, no, delay has not been condoned and all those things, no objection was filed. I'm not aware of all those things. Then my colleague, my lord, has pointed out to this honorable court, this is the order. And your lordship, my lord, has read this order. But what happened was in the order, my lord, 4.3, there is an order passed by your lordship. 4.3, it says, learned counsel for the respondent submits that he has to file objections to for IA number 10, my lord, is a typing mistake. And IA number 2 for condonation of delay. And he was not aware of the orders. The orders passed without considering the objections and he will file an application. This is totally wrong. A wrong submission was made by the counsel. And this honorable court, my lord, is though my lord, he said he will file an objection to condone the delay, and your lordship has permitted. That's why, my lord, I filed this application to recalling this order. Your lordship may kindly recall this order on 4/3/2025. It is totally, my lord, the council should know what has happened, transpired in the previous date of hearing, and he has to make a submission before this honorable court.
The council, if his counsel also was prepared enough to assist this court, this problem wouldn't have happened.
No.
The registrar had put up a condonation of delay of 10 days
Both of you
application.
are arguing like this. I won't hear this.
He has
one.
filed an affidavit to that effect, my lords.
What is that?
He says he's alleging that I have misled this court. And my lordship also, he says in para number 7, my lords, he makes a reference to this court, hence dated 4/3/2025 is required to be recalled, as otherwise the order passed by the coordinate bench could be reviewed by another bench and roster is changed if which is not permissible, and if things are not allowed, no case would reach its finality. My lords, is this required? One mistake has happened because the registry has posted the IA of condonation of
If a
10
recall
days.
petition, if he files, this court will not hear the recall petition. That recall petition, if he wants to file, court cannot stop him. If he files a recall petition, it will go before the appropriate, the court which has passed the earlier order. They will recall it. If the court feels that the order that is passed by the court is correct, it will not recall. How are you assuming that this matter will be heard by this court, that IA that will be filed by him?
No. My submission is this. My lord, a petition was filed. There is a delay, which appears before this honorable court. This court condones the delay. My submission is
Please
this.
understand. Please understand. He says,
after
that order that is passed by the court saying that the delay is condoned after hearing the other side is not correct, is what he said.
He was not there. I was there. I was present. His senior was there. Srinivas was there.
Please understand what the court is saying.
Yes, my lord.
Then I said, if that is the case, you move an appropriate application. And did the court say that application that is going to be filed will be heard by this court?
I am not saying that.
I'll not hear it.
My submission is this.
Earlier also today, some other matter has come of that nature. They wanted to file an application. They filed. It came up before me. I said it should go before the judge who has passed that order. This court will not recall. If even in his place, if you come and tell the court that it has not transpired that day like this, it is the other way around. Then because I am not the person who has heard it.
That's true,
so go before the court, and whatever your submission is, make before the court.
My submission is this. When this
No,
court
you cannot ask for recall of this
records the order. Well, this court has condoned the delay after hearing. There is an order sheet. Everybody has to abide by this order sheet.
You cannot stop the court from passing an order. I have not passed any order detrimental to your interest. I have to consider the other side who has stated that order has been passed without hearing me or something he said.
Yes.
That I've recorded. Now it will be this, if at all he files a recall petition, it will go before the concerned, the judge who has passed the order. She will decide it, whether it is right or wrong. No, you cannot tell the court that this order has to be recalled. How can you tell the court?
Because the delay has already been condoned.
If that is what I can't help it. Please come. I am There is a.
Lord, basically, my lord, it's a mistake of the registry, my lord, which has not verifying the order sheet.
if at all he
Yes.
comes up with an application, in that if you say all this, court will look into it. Note that the manner in which your application is filed, all that I cannot consider now. The IA number 1 of 25 is filed to recall the order dated 4/3/2025. When the matter came up before this court on 4/3/2025, then counsel for the respondent submits that without filing, he has to file objections to IA number 10 to condone the delay, and he was
La,
not
10
aware.
illa, 10 is wrong.
IA number 2 of 24 to condone the delay, and he was not aware of the orders. The order is passed without considering objections, and he'll file an appropriate application. Considering his submission, this court has passed an order and directed the matter to be listed on 24/3/2025. Now an application is filed to recall the said order. In support of the said IA, the learned counsel, it is been stated that when the matter came up on 8/2/2025, the learned counsel for the appellant and the counsel for the has appeared, and the counsel for the respondent has filed objections to IA number 2 of 24 seeking condonation of delay of 10 days in filing and accepting the reasons mentioned in the affidavit. However, IA number 1 of 2024 for stay filed by the appellant, the counsel for the respondent has taken 2 weeks' time to file objections. It is stated that on 4/3/2025, the matter was listed before this court along with IA number 2 of 24 for condonation of the delay of 10 days and also IA number 1 of 24 for stay. So, though the IA number 22 of 24 had already been condoned by the order dated 18/2/2025 by the office of this court. The above matter was represented, it is stated that the above matter was represented by his colleague when the matter got reached at 4:45 p.m. and she has mentioned about the order passed on 18/2/2025 on IA number 2 of 24, which has already been condoned. However, it was informed to him, to the advocate by colleague, that a junior colleague of Sriniva's DEC, who was represented by the respondent, has submitted before the court that the delay has not been condoned and opposed for the same. However, this court, at the request of the colleague, has gone through the order dated, and this court has perused the order and found that the delay has already been condoned, for which the said junior counsel has informed that he was not aware of the said order. And in the IA, the order of the learned judge and the order of this court were extracted. It is stated that the order is contrary to the record, order sheet maintained in the above appeal, and in view of the fact that the delay has already been condoned on 18/2/2024 after hearing both the counsels appearing for the parties, and it's a duty of the counsel who represent the case to know the previous order passed in the said case, particularly when he had not represented the above case on the previous date of hearing. Though this court has noticed that the submission made by the counsel for respondent is not correct after perusal of the order sheet dated 18/2/2025, this court has passed the order on 4/3/2025 in spite of the colleague has pointed out the factual aspect of the matter. Hence, the order dated 4/3/2025 is required to be recalled, as otherwise every order passed by the coordinate bench could be reviewed by another bench after roster is changed, which is not permissible, and if such things are allowed, no case would reach its finality. It is stated that the advocate has viewed the live telecast of the entire proceedings, which has taken place on 4/3/2025 in the official website. And it's only thereafter he is filing this affidavit along with an accompanying application for recalling the order. Hence, question of filing an application for review of the said order does not arise. Hence, it's necessary to recall the order dated 4/3/2025 in the appeal. And if the application is not allowed, it would cause irreparable loss to the respondent. In line with the affidavit that is filed, the learned counsel has argued before this court. The assumptions and presumptions of the learned of the advocate that this court is going to recall the order passed by the other judge, other learned judge, is most unwarranted unwarranted statements made in the affidavit. When a submission is made before the court that a particular order is passed by the previous court without notice or without hearing them, and when the court had permitted him to, court has gave him the liberty to move an appropriate application, the advocate cannot presume that that would be heard by this court. When advocate, when he is aware of all the proceedings and the procedure to be followed, should also know the procedure that when an order has to be reviewed, it would be reviewed by the very same court which has passed the order, but not by another judge hearing the matter. In this case, such an application, if at all, is filed by the respondent, and when it is placed before the court, if he comes up with his objections, the same would have been considered by the other learned judge. And the tone and tenor and the manner in which this application is filed, it cannot be, this court is not able to appreciate. And this court finds no reasons to recall the order. Accordingly, I number so and so is dismissed.
But the very fact that the IA is not, delay is not noted here shows that it is allowed.
Yes, next.
Much of it.
Serial number 12. VB Sidramaya.
Yes. No representation. This is matter day after tomorrow for dismissal.
For admission, serial number 13. Shekhar Badigar.
My lord, this is the wife's petition seeking transfer from Bangalore to Mysore. The respondent has been served as per the respondent has been served as per the cause list.
Seeking transfer from where to where?
From Bangalore to Mysore, my lord.
Distance?
300 kilometers, my lord. Approximately 300 kilometers takes about 4 to 5 hours.
And when is the MC?
The MC is dated 2022.
When the stay was granted?
The stay was granted on the last date, my lord. I am not very I don't have the date handy.
It was granted on 28/5.
Please,
what is the present stage of the proceedings?
My lord, it is actually, the matter was referred for mediation, my lord. The respondent.
Has the trial commenced?
Trial has not commenced.
Please come. The present petition is filed seeking transfer of MC number 2123 of 2022 pending on the file of the 3rd Additional Principal Judge Family Court, Bangalore. To where?
To a competent jurisdictional court in Mysore.
There are so many courts in Mysore. Family court.
Family
What is
court.
competent court? You should tell the court. There can't be a prayer like this.
Jurisdictional family court in Mysore, it's written there, my lord.
There are so many family courts in Mysore. 6 or 7 family courts are there. In which jurisdiction you come, that you have to mention. Court will not, do other guesswork.
My lord, the matter may
Yes.
be posted day after tomorrow. I'll
Yes, day
provide.
after tomorrow.
Please.
Yes, next.
14 dismissed, 15.
What is this? 14? 14 dismissed as withdrawn.
Well, as one more connected matter is there, my lords. I filed writ petition number 4807 of 2025. That has to be connected with this matter.
P?
No, WP 4807 of 2025.
How it should be connected to
The
this?
reason is this, my lords. Initially, my lords,
Now, what are the CP about?
the CP is about transfer of original suit, my lords, filed by the respondent husband. In respect to the same, my lords, MC petition was filed by the petitioner herein against husband seeking decree of divorce as well as the rights over the same property, my lords. The property which is presently has filed the suit. Family court decreed the suit. Respondent comes in appeal before this honorable court. The honorable division bench, my lords, upholds the order passed by the family court, wherein court has already declared that petitioner has equal rights over the property, my lords. Now suit is filed seeking declaration that he is the owner of the property. Therefore, my lords, I have filed the writ petition seeking questioning of the suit because manifestly, my lords, the abuse of the process of law.
Seeking
the return of questioning of the plaint, my lords.
Reject the plaint.
Please, my lords.
Hmm.
That is fine, my lords. Both has to be clubbed together and heard, my lords.
Well, I have not received.
That is irrelevant. Rejection, why it should be tagged on to this? Whether the case has to be transferred or not is the issue. You're seeking transfer.
Please, ma'am, once that, my
That
lords,
is-
the once
that
that matter
is
is
a-
heard, my lords, this becomes redundant is the.
Let you take courts, or your own courts available to you on that. Now let us see, where from you're seeking transfer to where?
In so far, that merit of the matter, my lords, day after tomorrow.
Oh, day after tomorrow. It has
Or-
nothing to do with that.
Please,
This is matter day after tomorrow. Seek
Please.
the request of land counsel for the petition.
intermodal to be extended.
Intermodal order granted is extended.
Sangamesh RB,
No representation. Just post it for day after tomorrow. Yes.
17. Puneet C.
All are served.
All are served.
Hmm.
Served and unrepresented.
Hmm. What is this
The
transfer?
transfer of suit, my lord.
Hmm. From
Suit
where to
for,
where?
suit for partition from Kunigal to Bangalore. There are two suits, please, my lord. I have sought for two prayers. Two suits have been filed. My lord, give facts first, please, my lord. Now, in the year 2019, please, my lord, petitioner's husband and respondent number 12 herein were brothers and sisters. Respondent number 12 herein, she executed a registered release deed in favor of the husband of the first petitioner. Well, first petitioner husband died in the year 2022 out of a liver jaundice. Immediately, please, my lord, within 4 months from the date of death of the husband of the first petitioner and the brother of the respondent number 12, respondent number 12, she files a civil suit in Bangalore seeking as a relief of declaration and a partition, please, my lord. Declaration that the registered release deed executed by the respondent number 12 in favor of the husband of the first petitioner herein is concerned as null and void, and consequently for the relief of partition is concerned. Now, this being the case, please, my lord, immediately, please, my lord, within a span of not less than 7 to 8 months, respondent number 2, who is the mother-in-law of the respondent number 12 herein, who are residing under the same roof, having knowledge of the institution of the suit filed by the respondent number 12 herein, she files another suit in Kunigal in respect of the very same properties are concerned. My lord, that is also a suit for partition.
Kunigal suit is of which year?
Please, my lord, one is of the year 2022 and one is of the year 2023.
Kunigal is which year?
My lord, Kunigal is of the year 2023.
Hmm.
2023. Now the suit
Give the
in
file. Hmm.
I am requesting, please, my lord, seeking, my lord, transfer of the suit in the Bangalore to Kunigal. Why? Because that's a comprehensive suit for partition where all the family members are being reset. Please.
Kunigal suit is a later suit.
Kunigal suit is the later suit, not in dispute, please, my lord.
Who filed Kunigal suit?
My lord, the mother-in-law of the respondent number 12.
You want your suit to be transferred to Kunigal?
I am a defendant in that suit.
In both the
in
suits?
both the suits, I am the defendant. In both the suits, I am the defendant, and in fact, I am the contesting defendants in respect of the suit properties are concerned. Why? Because I have.
Let's see the schedule of the properties.
Please, ma'am.
First, the Bangalore suit. What is the suit
Bangalore
number?
suit, Bangalore suit. My lord, may I? At page number 49.
What is the suit number?
My lord, suit number OS 4817 of 2022. Filed by respondent number 12 only against the petitioners herein and one Netravati. My lord, schedule is at page 49 of the petition.
Then show me the next suit.
My lord, next suit is at page number 28.
This is OS number.
This is OS number 325 of 2023.
Hmm.
Now the schedule, item number 1 to 4, please.
All
my
the
lord.
defendants are also one and the same.
Well, defendants are one and the same.
Parties are one and the same.
In fact, please, my lord, in Bangalore suit, my lord, the parties are only the petitioners herein and respondent number 12 and respondent number 13. That is in family, my lord. Suit between in family. Whereas the suit in respect of the Kunigal is concerned, please, my lord, involving the sisters of my father-in-law. Page 28, item number 1 to 4 are situated in the jurisdiction of Kunigal, whereas in page number 49, Bangalore suit B schedule. One and the same. Whereas in respect of A schedule is concerned, please, my lord, in Kunigal suit, item number 5.
1 minute, 1 minute. Same properties as it
Same
is.
same properties. In fact, kindly peruse the cause title, please, my lord.
And the relief is also partition in both.
Relief
the
is
matters.
also partition. In Kunigal, it's a relief
You are-
of partition.
1 minute, you are arrayed in Bangalore suit as defendant number.
I am defendant number 1 and 2.
In Kunigal suit,
In Kunigal suit, defendant number 11, 12.
how these property, where the properties are situated?
My lord, properties, my lord, item number 1 to 4 in the Kunigal suit, please, my lord, are situated in the jurisdiction of Kunigal. One property is situated in Bangalore. Since one property is situated within the jurisdiction of the Bangalore, please, my lord, my sister-in-law, she files a suit for partition in Bangalore, taking the cause of action as
So out of 5 properties, 4 properties are in Kunigal, 1 property is in Bangalore.
Bangalore. Kindly peruse, my lord.
One more thing. This Bangalore suit,
please,
the plaintiff is arrayed as
respondent number 12.
Defendant.
In Kunigal suit, please, my lord. My lord, defendant number 10.
Defendant number
10.
You are 11 and 12.
I am 11 and 12. Can you see the cause title address, my lord? It is the same. Mother-in-law and sister-in-law. I'm sorry, daughter-in-law. Lord, I am seeking for transfer of Bangalore to Kunigal.
The present petition is filed. Seeking transfer of OS number 4817 of 2022, pending on the file of the first additional city civil court and session judge Bangalore, and transferred the same. Oh, there is something wrong with the prayer. Look at it.
No, please, my lord. I am seeking, my lord, for withdrawal of the suit in OS 4817 of 2022 and to transfer the same to the senior civil judge JMFC Kunigal.
Read the prayer.
Lord, to withdraw the suit in OS 4817 of 2022.
No, next,
please, my lord. To withdraw the suit, either alternative. I am seeking alternative. Either this or this.
The prayer is the.
I am restricting only to the prayer A.
Seeking transfer of OS number 4817 of 2022, pending on the file of the first additional city civil and session judge Bangalore, and transfer the same to the principal civil judge and JMFC Kunigal, or in the alternative to withdraw the suit in OS number 325 of 2023, pending on the file of the principal civil judge and JMFC Kunigal, and to transfer it to the first additional city civil and session judge Bangalore. It is submitted that the petitioners before this court, or the defendants number 1 and 2 in the suit that's filed on the file of that's filed before the court in Bangalore, that is OS number 4817 of 2022, and arrayed as defendant number 11 and 12 in the suit, that is OS number 325 of 2023, filed before the Kunigal court. It is submitted that the suit scheduled properties are 5 in number. In that 4 properties, or in both the cases, the suit scheduled properties are 5 in number, and 4 properties are within the jurisdiction of Kunigal court, and 1 property is within the jurisdiction of Bangalore High Court. As such, the sister-in-law of the petitioners herein has filed the suit here in Bangalore. Thereafter, the respondent respondent number 2 in the present case has filed the suit before the courts at Kunigal. It is submitted that there are how many respondents in this suit?
In OS
in the Bangalore suit?
In Bangalore, only 3 different.
In the Bangalore suit, there are only 3 respondents, whereas 3 defendants, whereas in the suit filed by the respondent herein, There are about
14.
14 defendants in the suit.
All are residents of Kunigal.
Submitted that the suit is a comprehensive suit that's filed before the courts at Kunigal, and he submits that he has no objection either to transfer the suit from Kunigal, the pending suit from Kunigal to Bangalore or Bangalore to Kunigal. But the purpose of filing this petition is if both are decided by the same court, there not be any scope for a conflicting of judgments, and it would be in the interest of both the parties. All the respondents are served. There is no representation. No wakalat is filed on behalf of the respondents.
Few of them have been sought for dispensation. My lord.
Who are they?
My lord, they are placed ex parte.
1 minute. Respondent 1, 2, 8, 12, 13, 14.
Respondent number 1.
1, 2, 8, 12, 13, 14 are served. And notice to, and on 27/2/2025, notice to R1 is held sufficient. And by order dated 21/3/2025, notice to R3 to R7 and R9 to R11 are dispensed with at the risk of appellant.
They placed trial ex parte.
The having heard the learned counsel for the petitioner, produce the material on record. The material on record discloses that the two suits, one is filed before the courts at Bangalore, other filed at the courts at Kunigal. Both the cases were filed seeking the relief of partition. In the suit at Bangalore, there are only 3 respondents, whereas at Kunigal it is 14 defendants, and the properties, 4 of the properties are situated at Kunigal, and only 1 property is situated at Bangalore. Considering the fact that it is between the same parties and the same properties in both the suits, it could be in the interest of the parties, and also to avoid conflict of judgments, this court deems it appropriate to withdraw MC number.
Yes.
OS number 4817 of 2022, pending on the file of the first additional City Civil and Session Judge Bangalore, and the same is transferred to the Principal Senior Civil Judge and JMFC Kunigal to be tried along with OS number 325 of 2023. Accordingly, the appeal is allowed, the petition is allowed.
Please. Transfer to the Senior Civil Judge and JMFC.
Whatever it is, as
Please.
per what you have mentioned, it will
Please.
come.
18.
Please.
Krishna Swamy, yes.
Please, Lord, I appear for.
Yes.
My Lord, the suit in OS 99/2001 at Chitradurga is filed by the granddaughter against the grandmother. The suit for partition. 2 properties are there in Chitradurga. 2 more properties are included. It's in Bangalore. She is about aged 80 years. It will be not possible for her to travel from Bangalore to Chitradurga and to instruct her advocate.
No, Bangalore who filed, grandchildren filed.
I didn't get your lordship.
Suit is filed in Chitradurga.
Chitradurga.
By the
19
granddaughter is his case. The granddaughter has filed a suit for partition in
He stays in
Chitradurga.
Bangalore.
Yes, my lord. Yes, petitioner is in Bangalore. She is aged about 80 years. She has got her own ailments. What she requests is, please withdraw the suit from to have it transferred to.
That 1 property is Bangalore.
Two scheduled properties are in Bangalore. Two are in Chitradurga.
What do you say?
No difficult. It can be transferred. Only thing is, my lord, it's at the stage of cross-examination of the PW2. My lord, if only your lordship, I understand your lordship. If direction could be passed to expedite them, that.
Yes. Which year is the suit?
2021. IFR amendment was filed. It was allowed. That was challenged. State, CP, state.
The present MC is filed. A present petition
OS.
is filed. Present petition is filed seeking transfer of MC number, OS number 99 of 2021, pending on the file of the first additional Senior Civil Judge Chitradurga, and to transfer the same to the City Civil Civil Court, Bangalore. It is stated that the grandchildren have filed the suit seeking partition against the
Granddaughter Matraswamy.
grandmother.
Granddaughter has filed a suit.
That's
Only
what I'm
one
saying.
granddaughter.
Granddaughter has filed a suit for partition against the grandmother, seeking partition of the suit scheduled properties. The suit scheduled properties are 2 in number. They're 2 in number.
No, 4 in number. Subsequently, he amended the plaint. So there are 4
2 properties are situated at
Chitrurga, 2 are in Bangalore.
and 2 properties are situated at Bangalore. It is submitted that the grandmother is aged about
80
years, and it's difficult for her to travel all the way to Chitradurga to contest these matters. The counsel appearing for the respondent submits that shall I record your objection or no objection? Submits that they have no objection to transfer the petition from Bangalore, from Chitradurga to Bangalore, considering the fact that there are 2 properties in Bangalore and 2 at Chitradurga, and considering the age of the petitioner, grandmother, who is aged about 80 years, this court deems it appropriate to withdraw so-and-so, pending on the file of the so-and-so, and transfer the same to the, which court?
Now, there are about 60 courts. It will be, your lordship may say,
Allotted as per the.
let it go before the principal city civil judge. Who will assign?
Principal city civil.
He will assign to any other.
To the, we have to say some court. The
It
principal.
may be placed before the principal city civil judge who will assign.
Because I cannot
Shall
choose.
be transferred to the, and accordingly transferred to the courts at Bangalore. The same shall be placed before the principal city civil judge to allot the particular court. The petitioner shall cooperate with the trial and shall not seek for unnecessary adjournments.
Obligatory.
19, Prabhalingamurthy.
Yes.
Vice petition. Transfer from Bangalore to Gubbi. Transfer from Bangalore to Gubbi.
Distance?
Distance is 1 kilometer per single. 240 kilometers up and down.
Wife,
And
wife petition.
a wife petition. One minor child is there. 2.5 years.
93 kilometer from one side, Mala.
Huh?
93 kilometer from one side.
Then what is 240? You have calculated the through and fro.
192.
When anybody asks
90
you distance, you have to tell how much, what is the
per-
distance
per-
to go there, not to come.
Both up and down.
It's 90 kilometers.
93 kilometer.
93 plus one side.
And my lordship, I
And,
had filed a petition for divorce. Prior to that, I filed petition for restitution of conjugal rights. Their notice was served and she remained absent and
This MC is the chair.
at 2024. Ma'am.
And
After
she
that, she has filed a petition before Gubbi Senior Civil Judge for seeking of maintenance petition under section 125. Now the family court, my lordship, it is petition pending for, she appeared and now it is pending for a refer to mediation.
The transfer.
Transfer, my lordship, only to arrest the respondent, my lordship, a necessary adjournment.
But what to do?
So
Please
that
come.
a specific direction
What
maybe.
is the age of the girl?
Yeah, 2.5 years.
Huh?
Daughter is 2.5 years.
The petition is filed seeking transfer of MC number 7045/2024, pending on the file of the 6th Session Principal Judge, Family Court, Bangalore, the Senior Civil Judge and JMFC at Gubbi. It is stated that the facts of the case are the marriage has taken place on 16/9/2021 at
Mahalakshmi Kalyanam Mandapam.
at Kadepalya village, Tumkur district. In view of the differences between the parties, the husband has filed MC number 7045/2024 seeking this seeking resolution of the marriage. And the wife has filed criminal miscellaneous for maintenance, that is criminal miscellaneous 18 of 2025 on the file of the at the courts at Gubbi.
Petition civil judge junior.
it is stated that the distance between both the places is about 90 kilometers, and she has to take care of the child who has to take care of the child. It is difficult for her to travel on all the date of hearings. Then counsel appearing for the respondent submits that earlier he has filed a petition for restitution of conjugal rights, and thereafter I filed this petition for seeking divorce. It is submitted that the wife is not only to harass the petitioner. The present application is fine. Present application is fine. Having heard the counsels on either side, peruse the material on record, considering the fact that the wife has already instituted criminal misdemeanors, which is pending on the file of the
Additional civil judge and
Gubbi, and the distance between the places is 90 kilometers, and she has to take care of the child. In this court, accordingly, this court is passing the following order: so and so is withdrawn from so and so and transferred to so and so.
And my lordship,
The petitioner shall cooperate with the wife shall cooperate with the trial and shall not seek for unnecessary adjournments.
my lordship, time, specific time may be fixed. Request for a duration fixing of time.
See, of
At least
2024, no time for that.
Because my lordship, my problem is I'm working as a driver.
Whatever
my
your
lord.
problem, court cannot give a direction to dispose of a 2024 matter when 19 to 18 matters are pending before the court. It's not right. Yes.
Chandrasekhar P. Patil.
Please, madam. Wife's petition seeking transfer from Davangere to Swaraba, my lad.
What is the distance?
Distance is, my lad, 136 kilometer, and she has already filed on
MC of
maintenance
which year?
petition. MC is 24, 2024.
It appears 2023.
212 of 24. 212 of 24.
Where do you get that?
Annexure B, ma'am. B, page number 19. MC 212 of 2024.
It shows 23. It shows 23, 187 or 23.
Annexure B, page number 15, ma'am.
19.
Annexure C, your lordship is saying.
Uh,
That is filed by
Page
the
number 19. I'm looking at 19.
page number 15, madam, 15. 15.
What is the stage now?
Stage is, my lord, for filing objections.
The present petition is filed seeking transfer of MC number 212 of 2024 pending on the file of the Family Court Davangere to the civil judge, senior division at Sorava. It is submitted that the distance is
136 kilometers.
136 kilometers, considering the submission of the Rent Council and the distance between both the places. There shall be stay of all further proceedings and hand summons, and you shall file the memo by 9th of April. And listen, if the same is filed, by 15th of April, and if it is memo is filed, list the matter on 16th, or else the stay granted by this court stands vacated.
Please.
List number 3.
Yes, what is to be done with all this? Tomorrow, these 13 file hearings in the first list. They must have already uploaded the list. Huh? Then make it a second list, file hearing matters. All the file hearing matters in the second list. Whatever that has to come in the second list will come in third list.
Submission was tomorrow. Serial number 5 in the list number 3 may be posted 7/4, my lord.
Why?
I'm going out of town, sir.
2014, we don't even know when it will reach. When do you want?
7/4.
Huh?
April 7th.
7/4 at the request. Next. It will come tomorrow in second list.
Please.
DC ಬಂದಿತ್ತಲ್ಲ ಮೇಡಮ್, DC ಇತ್ತಲ್ಲ, DC ಬಂದಿದೆ ಅಂತ ಹೇಳಿ 5 ಗಂಟೆಗೆ.
ಮಾತ್ರ ಅದನ್ನೆಲ್ಲ ಸೇರ್ಸ್ಕೊಂಡು ಅಲ್ಲೇ ಇಟ್ಟಿರ್ತೀವಿ. ಅದೇ ಶೀಟ್ ಕೊಡ್ತೀನಿ. ಹೇಳ್ತೀನಿ ಇವ್ರಿಗೆಲ್ಲ ಅಲ್ಸಂಗೆ. ಇವಾಗ ಯಾವ ಲಿಸ್ಟಿಗೆ ಹಾಕ್ಸೋದು ಮೇಡಮ್? ಹೇಳ್ತೀನಿ. ಅಲ್ಲ, ಈಗ ಥರ್ಡ್ ಲಿಸ್ಟ್ಗೆ ಮೇಲ್ ಬರಂಗ ಹಾಕ್ಸ್ತೀನಿ ಅಲ್ವಾ? ಇದನ್ನೆಲ್ಲ ಥರ್ಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಮೇಲ್ ಬರ್ಸ್ಬಿಡ್ತೀನಿ. ಎಲ್ಲರೂ ಕೊಡ್ಲಿಲ್ಲ, ನಾವು ಹೇಳ್ಬೋದಲ್ಲ, ಎಲ್ಲ ಥರ್ಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಟಾಪ್ ಅಲ್ಲಿ ಹಾಕ್ಸ್ಬಿಡ್ತೀನಿ. ಅಂದ್ರೆ ಫೈನಲ್ ಇಯರಿಂಗ್ ಅಲ್ವಾ, ಮಿಕ್ಸ್ ಮಾಡ್ಸೋದ್ ಬೇಡ. ಏನ್ ಸರ್ ನಿಮ್ ಕಾಲ್ಗುಣ ಹಿಂಗೆ ಅಂತ ನನಗೆ ಗೊತ್ತೇ ಇರ್ಲಿಲ್ಲ. 20 ಡಿಸ್ಪೋಸಲ್ ಮೇಡಮ್. ಲಲಿತಾ ಎಲ್ಲ ಲಿಸ್ಟ್ ಕ್ಲೋಸ್ ಮಾಡ್ಬಿಟ್ರ ಹೆಂಗಪ್ಪ? ಹೌದಾ? ಇವಾಗ ಈ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಮ್ಯಾಟರ್ಗಳೆಲ್ಲ ಉಳಿದಿದೆ ಮೇಡಮ್. ಯಾವ್ದು ಲಿಸ್ಟ್ ಕ್ಲೋಸ್ ಮಾಡಿಲ್ವಂತೆ. ಈ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ನ ಅದ್ರಲ್ಲಿ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇರುತ್ತಲ್ಲ, ಅದನ್ನ ಏನ್ ಮಾಡ್ತಾರೆ ಅವರು? ಇವ್ರು ಇದು ಒಂಚೂರು ಬನ್ನಿ, ನೀವು ಇಲ್ಲಿಗೆ ಬನ್ನಿ. ಬಂದ್ಬಿಟ್ಟು ಹೇಳಿ ಮೇಡಮ್. ಸೀರಿಯಲ್ ನಂಬರ್ ಹಂಗೆ ಫೈನಲ್ ಇಯರಿಂಗ್ ಮ್ಯಾಟರ್ ಹೆಂಗ್ ತೆಗ್ದು ಹಾಕ್ಲಿ? ಸೀರಿಯಲ್ ನಂಬರ್ 32 ಫಸ್ಟ್ ಲಿಸ್ಟ್. 32 ನ 27/3 ಹೇಳಿದ್ರು. 33 27/3 ಡೇ ಆಫ್ಟರ್ ಟು. ಡಿಸೆಂಬರ್ 2 ಇಂದ ನೋಡ್ತೀನಿ. ಡಿಸೆಂಬರ್ 2 ಅವ್ರು ಇವ್ರು ಬರಲ್ವಾ? ಯಾರು ಇರ್ತಾರಾ? December 2 serial number 1 27/3. December 2 31st February. No representation 27/3. No list of service. 4 ಸರ್ವಿ ಆಮೇಲೆ ಏನೋ ಫೈಲ್ ಮೆಮೊ ಟು ದಟ್ ಎಫೆಕ್ಟ್. ಅದಕ್ಕೆ ಫೈಲ್ ಮೆಮೊ ಟು ದಟ್ ಎಫೆಕ್ಟ್ ಬೈ ಹಾಕ್ಬೇಕು ನೀವು. ಬೈ 84. ಫಿಫ್ತ್ನು ಅಷ್ಟೇನೆ. ಫೈಲ್ ಮೆಮೊ ಟು ದಟ್ ಎಫೆಕ್ಟ್ ಬೈ 84. ಆಯ್ತಾ? ಅದೂನು ಅಷ್ಟೇ, PF ಕಟ್ಬೇಕು, ಅದಕ್ಕೆ ಮೆಮೊ ಹಾಕ್ಬೇಕು ಬೈ 84. 7 ಪೋಸ್ಟ್ ಆಫ್ ಸರ್ವಿಸ್ ಆಫ್ ನೋಟಿಸ್. ಅದು 7 27/3 ಅಂತ ಹೇಳಿದ್ದಾರೆ ಮೇಡಮ್. ಹೌದು, 27/3. ಥರ್ಡ್ ಲರ್ನ್ ಕಾನ್ಸೆಪ್ಟ್ ಆಫ್ ಪಿಟಿಷನ್, ನೋ ರೆಸ್ಪಾನ್ಸ್ ಆಫ್ ರೆಸ್ಪಾಂಡೆಂಟ್. ಅಡಿಷನಲ್ 27/3. 8 ಅದು ಅಷ್ಟೇ. 84 ಬೈ 97. 9 ಟು ಇಶ್ಯೂ ನೋಟಿಸ್. 17/4 ರೂಲ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ, ಪೇಜ್ ಇದೆಲ್ಲ ಸೇರು. ಮೇಡಮ್ ಏನ್ ಮಾಡಿಸ್ತೀನಿ ಗೊತ್ತಾ? ಫೈನಲ್ ಇಯರಿಂಗ್ ಅಲ್ಲೇ ಇರಲಿ, ಟಾಪ್ ಅಲ್ಲಿ ಬರ್ಸಿಸ್ತೀನಿ ಲಿಸ್ಟ್ 3 ಲಿ. ಆಯ್ತಾ? ಸೀರಿಯಲ್ ನಂಬರ್ 12 27/3, 13 27/3, 15 27/3, 16 27/3 ಅದೆಲ್ಲ ಮಾಡ್ಕೊಡ್ತೀನಿ ಇದೆಲ್ಲ. ಓಕೆ, ಇದೆಲ್ಲ ಅಲೋದು. ಇದೊಂದು ಇಯರಿಂಗ್ ಅಲ್ಲಿ, ಇಯರಿಂಗ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ನಿಮ್ಗೊಂದು ಆಗಿದೆ 74. ಸೀರಿಯಲ್ ನಂಬರ್ 5 ಕೊಡಿ ಸದಾನಂದ ಅವರಿಗೆ. ಓಕೆ, ಸಿ ಯು ಬೈ. ನಟರಾಜ್ ಇದ್ದಾರೆ ಇವತ್ತು. ಬೇರೆ ಅಲ್ಲ, ಬ್ರಾಂಚಿಗೆ ಕೊಡಿ, ಅವ್ರಿಗೆ ಹೇಳ್ಬಿಡು ಸರ್. ಆ ಕಡೆ ಲಿಸ್ಟ್ ಏನಾರು ಇದೆಯಾ? ಒಂದು ಎಕ್ಸ್ಟ್ರಾ ಲಿಸ್ಟ್ ಇದೆಯಾ? ಕೊಡಿ ಸರ್. ಟೈಮ್ ವೇಸ್ಟ್ ಮಾಡಕ್ಕೆ ಯಾರಿಗೂ ಬಿಡಲ್ಲ. 21 ಸರ್. ಏನು ಬೇಡ ಸರ್. 2 ನನಗೆ ಎಷ್ಟಾಯ್ತು? 5 ಒಂದಿಗೆ ಪಿನ್ ಮಾಡ್ತೀವಿ. ರಿಪೀಟ್ ಆನ್ ಟಾಪ್ ಅಂತ ಹಾಕ್ತೀನಿ ಇಸ್ 3 ಆಯ್ತಾ ಆನ್ ಟಾಪ್ ಅಲ್ಲಿ ಹಾಕ್ತೀನಿ ಎಲ್ಲಾನು ಇನ್ನು ಹಾ ಒಂದು ನನಗೆ ಕೊಡಿ ನಾನು ಇದು ಪಿನ್ ಮಾಡಿ ಕೊಡ್ತೀನಿ ಅಷ್ಟೇ ಎರಡೇ ಹಾ ಏನ ಅವ್ರು ಸುಸ್ತ ಮೇಡಮ್ 21 ಡಿಸ್ಪೋಸ್ ಅಲ್ಲ ನೀವು ಬರೋಷ್ಟೊತ್ತಿಗೆ ಸುಸ್ತಾಗಿರಲ್ವಾ ಬೆಳಗ್ಗೆ ಎಲ್ಲ ಟೋನ್ ಚೆನ್ನಾಗಿ
ನಂಗೆ ಟೋನ್ ಚೆನ್ನಾಗಿರ್ಬೇಕಲ್ಲ ಹೇಳ್ತೀನಿ ಹೋಗ್ಬಿಟ್ಟು ಮೇಡಮ್ ಟೋನ್ ಎನರ್ಜಿ